Pardon to mention, my lord. So land acquisition is a fresh matter, my lord. Fresh admission.
More than 8 years. May I pardon to mention, my lord? Your lordship have been pleased to have this hear this matter at length about this compulsory retirement and your lordship directed to we will listed this week. 15th.
Yes. This is a land acquisition rehabilitation research.
My lord, land acquisition matter, my lord. My lord, land acquisition matter, my lord. Of 2020.
Pardon to mention, my lords, item 29 has been compiled with after your honor's direction. Item 29 has been compiled with
Complied.
complied
Complied.
after your honor's direction.
Item 29.
29.
Only item?
Item 29.
No,
29.
that is the only item.
Yes,
Or any
that
other
is the only already compiled with.
So what do you want?
I have already received the certified copies and
No need to press
No-
for
no
it.
need-
You don't press for it.
yes, I don't want to press.
All right. The learning council for the petitioner item number 29 submits P29 by the
You will later.
WIU
Already. Oh, it is disposal. Place. Grievances with all supportive documents collected to consider it within the state of Tribunal. So we had taken it because this is that
IU is to be disposed now. IU number 15586 of 2020.
Well, this is wrongly listed.
Order number 2.
Now list this matter on mind. So it is disposal.
IU number so on so. Learning council for the petitioner submits that and the petitioner has appeared before the planning registered judicial and the certified copy of the present case also WBC number 738 of 2020 as required by him has already been handed over to him and therefore he does not want to face the interim application according to IU number 15586 of 2020. So that actually assured of I and they came out. These two assume, but that is pending. It's disposed of that IA is disposed. Yes.
Obliged.
Item 46. Plus item 46, that matter relates to preventive detention. On the last occasion, my learned friend has appearing on behalf of Union of India stated that he has filed a counter affidavit. But plus counter affidavit has been filed on behalf of OP number 3 with the sponsoring authority, not the detaining authority. So no counter has been filed so far as OP number 1 and 2 are concerned.
Yes, yes. Counter affidavit has been filed by opposite party number
But three.
3.
And nothing is mentioned in the counter that he is filing the affidavit on behalf of number 1 and 2.
Counter affidavit has also been filed on behalf of opposite parties number 4 and 5.
That I have got. That I have received just
So
now, of
you
course.
have got the counter affidavit of opposite party number 3
And
as
for
well as counter affidavit filed by OP number 4 and 5.
yes, please. My humble submission, Lordship, is detaining authority is OP number 2. So if OP number 3 is authorized to file a counter affidavit on behalf of OP number 1 and 2, then a memo should have been filed. Or means I will argue the matter plus even today after this.
Where is Mr. Pari? Yes, Mr. Pari, do you want to your opposite party number 1 and 2? They are the according to Mr. Katkia, they are the main authority. If you say that they don't want to file the counter affidavit, we can proceed. There is no problem. That is preventive detention.
46.
Item number 46, WPCRL number 129 of 2020. Under NDPS Act, this man has been detained by way of preventive detention, and the order of detention has been passed by the Joint Secretary, and Joint Secretary has been is the opposite party number 2.
2.
No counter affidavit has been filed.
Yeah, I think the NCB is a party.
No, NCB is a party, but they are not saying that on behalf of party number 2.
But we're filing the counter affidavit file.
You missed.
In
The
that case,
counter affidavit has been filed by 3, 4, and 5.
3, 4, and 5 yes.
Right.
Yes.
3 has filed one counter affidavit, 4 and 5 other affidavits.
Fine.
But you come to please annexure 1.
Yes, my lord.
You
This
see,
order was passed by the Joint Secretary.
right, he is opposite party number 2. So he is challenging this very order. So the counter affidavit is to be filed by this Joint Secretary. He has to justify, he has taken many grounds in the writ petition as to how this detention order, preventive detention order is illegal. And this not only annexure 1, annexure 2 is the grounds of detention. Those are all by opposite party number 2, who has not yet filed the counter affidavit. So that means he has nothing to say. Whatever the petitioner is mentioning in the grounds of challenge, that is not disputed by the opposite party
My
number.
lord, may I keep it to 10 days. In the
No,
meantime,
it's a preventive detention matter. We cannot on the ground of
or
detention
certain
itself,
time,
on the ground of
yes.
delay also itself, we can quash it. So the thing is that
Any sort that may be given.
If OP number 3, if OP number 3 is authorized to file the affidavit on behalf of OP number 1 and 2,
I'll
in
check
that
it up,
case-
my lord, but it can because on behalf of Union of India, none of the officials from the NCB or anything authorized. My lord.
no, OP number 3 is also
Either secretary or his subordinate, even the underside can file.
just a minute, we can keep it. We have to keep it this matter on 16. You just take instruction whether
Yes.
he is to file the affidavit
Or
or
not,
will
yes.
adjudicate on the
Or opposite party number 3, whatever has been filed is to be adopted by them.
Adopted by this. Yes.
same thing.
Yes.
Man, obliged.
The Mr. Janmejay Katkia, Land Council, appearing for the petitioner, submitted
My lord, can it be 20th because Delhi there is a today and tomorrow the holiday.
all right. He has received the counter affidavit filed by opposite party number 3. So also the counter affidavit filed by opposite party number 4 and 5. However, he submits that annexure 1 and 2, which are the order of detention, so also preventive detention, so also the grounds were passed by the Joint Secretary to Government of India, who is opposite party number 2 in this WPCRL. But no counter affidavit has been filed by the opposite party number 2. Mr. Pari, Deputy Solicitor General submits that the matter may be taken up on 20th of January 2025, so that we will obtain instruction as to whether any separate counter affidavit is required to be filed for opposite party number 2, or the counter affidavit filed by opposite party number 3 be adopted by the opposite party number 1 and 2. This matter.
Let's me instruct 1 and 2.
Yes, 1 and 2.
1 and 2 the
One.
first. This matter on 20th of January 2025.
Grateful to Lordship.
Weekly list, item number 1.
Yes.
This is the pension matter. This is a pension matter. We are claiming the pension matter on the basis of what OM issued by the government of India on 1/5/1987.
Who are the petitioners?
And what
Who are the petitioners?
Ashok Kumar Mohanty,
No. Who? Kumar Mahathi is by name. Who are
a
the
retired NWDA employee.
No, there are four petitioners here. Who are they?
They are all the retired employees of NWDA,
NWDM is
a National Water Development Agency.
National
Water Development Agency.
Which is coming under the Ministry of Jal Shakti, Government of India,
Government.
and which is a registered society.
Yes.
Government of
Lord,
yes.
we approach the Honorable Tribunal seeking that in view of the OM issued by the Government of India on 1/5/1987 will be covered by the pension scheme, and we should be extended the pensionary benefit.
You are challenging which order?
I am challenging the rejection order that here, Milord, in this writ petition, I am challenging the order of the Learned Tribunal.
That is
Annexure 1.
That is, Milord, Annexure 1. Learned Tribunal rejected my original application holding that since NWDA having its own CPF rules 1982, therefore that OM dated 1/5/1987 will not
Yes.
apply.
Don't go so fast.
Milord.
We want to know that. Come to paragraph number 1 of that impugned order.
Milord. That is page, Milord. Page 40.
It's not 45. It is
20.
the relevant page is running page 38 and internal page is 14. If you are placing the order dated 24/7, the relevant
Page 38, Milord.
38, right?
Yes.
Please.
The facts of these cases are briefly stated that the applicants in all the ways are the retired employees of NWDA, which was established as a society in July 1982 and was registered under the Society Registration Act 1860 and functioning under the administrative control of the Ministry of Water Resources to carry out detailed studies, survey, investigation in respect of peninsular component of national perspective for water resources development. For proper discharge of its day-to-day functions, smooth running, NWDA framed rules and regulations known as bylaw of the National Water Development Agency. In all these cases, the basic grievances of the applicants are that Government of India, Ministry of Personal, Public Grievances and Pension, Department of Pension and Pensioner Welfare, New Delhi issued office memorandum dated 1/5/1987 for change over to the central government employees from contributory provident fund scheme to pension scheme implementation of the recommendations of the 4th Central Pay Commission. In the said way, it was specifically stated that if no option is received by the date so fixed, specifically requesting to continue under the CPF scheme, the employees concerned will be deemed to have come over to the pension scheme. All the applicants were the beneficiaries of CPF.
the when circulars orders issued by the government of India from time to time are mutatis mutandis applicable to the employees of the NWDA. Therefore, the applicants ought to have been treated who have switched over to the pension scheme, and upon their retirement, they should have been paid pensionary benefits instead of the benefits flowing from the CPA. Hence, they have paid for direction to the respondents to treat them as employees under the pension rules 1972 in terms of OM dated 1/5/1987 and grant them pension and pensionary benefits with arrears and interest thereon.
So this was torn down.
Yes,
What is the relevant part of the order?
order Miller.
Yes.
Relevant part is Miller.
Which page?
Page
58.
9.
15. Running page 4.
Miller.
Just come to paragraph 11, 59 is the.
Your lordship, page 50, your lordship, kind.
50.
Page 50, 50, Miller. Paragraph 16.
50 form.
Page 50, Miller.
Yes.
Paragraph 16.
Yes.
In the instant case, the employees of NWDA are not civilian central government employees, as NWDA is not an organization of the central government, but an autonomous body.
No, it's an order of Delhi High Court.
No, my lord, Honorable Apex Court. They have quoted, my lord.
Yes.
Quoting this, the application was rejected. The government of India also, it is worth noting that the employees of NWDA who are subscribing the CPF scheme are governed by the National Waters Development Agency Contributory Provident Fund Rules 1982 and not Contributory Provident Fund Rules 1962. In that view of the matter, the employees of NWDA are covered under the third situation, and this is under the clause 7.2 of the office memorandum dated 1/5/1987 and not under the two situations envisaged under the clause 6.1 of the memorandum, and thus in view of the advice contained in clause 7.2 of the memorandum, the Ministry of Water Resources ideally should have consulted the Department of Pension and Pensioners Welfare for issuance of similar order as office memorandum dated 1/5/1987 for the employees of NWDA. However, the Ministry of Water Resources consulted the Department of Expenditure, Ministry of Finance in respect of the said matter, instead of consulting the Department of Pension and Pensioners Welfare. To that extent, the petitioners have added in consulting the matter of issuance of order of similar office memorandum dated 1/5/1987 to the employees of the NWDA to the Department of Pensioner and Pensioner Welfare. 17 million, your lordship, the result. As regards the reason given by the tribunal, predicated upon bylaw 28 of the bylaw NWDA is concerned, it would be stated that bare reading of bylaw 28 makes it explicitly clear that the rules and orders applicable to the central government employees are mutatis mutandis applied to the employees of NWDA only in cases where NWDA has not framed its own rules and regulations. In the instant case, as already noted in the foregoing parag, NWDA has framed its own contributory provident fund rules in the year 1982. In such circumstances, bylaw 28 has no role to play in the instant case, and the same should not have been restricted by the tribunal to apply the office memorandum dated 1/5/1987 to the employees NWDA. Therefore, your lordship directed.
Whatever it may be, whatever you are facing, it was the order of the Delhi High Court. You please come to paragraph number 8.
Paragraph 8, Milan.
Yes.
Milan.
That starts at page 48, which part you placed is a part of that order.
Yes.
That was pronounced by the Honorable Delhi High Court.
Milan.
Come to paragraph number 8.
8, Milan.
Read it from the beginning.
Undisputedly similarly placed.
Please go slowly. Yes.
Undisputedly similarly placed employees of the NWDA approached the CAD Principal Bench, New Delhi in OA number such and such, which was allowed by the order dated 8/2/2010. The respondent department challenged the said order of this tribunal before the Honorable Delhi High Court in WPC number such and such, which was disposed of by order dated 6/1 2011.
So that is the order that order you are placing some paragraph. Okay. Now you come to paragraph number 9.
Yes, Lord. In compliance of aforesaid order.
No, you just come to paragraph number 20, page 54.
Yes. Yes.
Running page 54.
The gist of the above.
Yes.
The gist of the above discussion is that impugned judgment dated judgment and order dated 8/2/2010 passed by the tribunal is faulty and deserves to be set aside, and we do not do so by we do so by formally directing that the impugned judgment and order dated 8/2/2010 along the original application filed by the respondents is set aside. However, in view of the discussion contained in para 15 and 16 above, we direct the Ministry of Water Resources to consult the matter of issuance of an order similar to the office memorandum dated 1/5/1987 for the employees of NWDA with the Department of Pensions and Pensioners Welfare, and thereafter take an appropriate decision in said regard with 4 months from the date of receipt of the copy of this order. Needless to state, while taking necessary decision, the Ministry of Water Resources and Department of Pensioners Welfare shall examine the concerns raised by the department expenditure, Ministry of Finance in the letter dated 16/3/2000.
Yes, then what happened? 9.
Then, my lord, in compliance of the aforesaid order, the Respondent Department considered the issue relating to the grant of pension and pensionary benefits, but the same was rejected by the OM dated 24/5/2013. The aggrieved employees of NWDA filed SLP number 31 such and such in 2011 before the Honorable Appeals Court, which was also were dismissed. Relevant portion of which is quoted herein below, my lord.
Yes, then come to paragraph number 10. Page number 56.
56. Thereafter, one of the employee of NWDA, namely Sir Rohit Kumar Sethi, filed OA number such and such before the CAD Principal Bench, New Delhi, praying for grant of pension and pensionary benefits. The tribunal, by placing reliance on the decision of the Honorable Appeals Court, dismissed the prayer by order dated 11/9/2019.
Now we come to paragraph 11. Page number 50.
We have carefully examined the issues involved in all the cases and arguments placed in support thereof, with reference to the bylaw of the NWDA vis-a-vis the decision of the Honorable Appeals Court in SLP number such and such. So also with the case filed before the CAD Principal Bench, New Delhi by Sir Rohit Kumar Sethi, and we do not find any substantial ground to differ from the view already taken in the cases, already taken in the above cases, especially in view of the clear-cut finding of the Honorable Appeals Court that employees of NWDA are governed under the NWDA CPF rules 1982. The OM dated 1/5/1987 is not applicable to them, that the employees of NWDA are not the central government employees at par with their counterparts, hence their claim of parity with central government employees is defeated. Yes.
What do you say?
My specific submission was before the learned tribunal and so also before this honorable court. There is no such NWDA CPF rules 1982. Therefore, your lordship, while admitting the matter, issued instruction to them to produce that NWDA CPF rules which they have produced along with their affidavit. Your lordship may kindly see that.
The Honorable Supreme Court has taken note of that rules, 1982 rules. How do you say that it is not? What you say that is not there?
From their document, it is proved that
we are not here to go by your disputed thing. Honorable Supreme Court has taken note of that particular rules, and that rules has also been traced by the learned.
Your lordship,
you say that that rule is not existent.
Just passing on the
for a moment, my lord, from their document, my lord, it is a bread and butter for the pensioners, my lord.
Yes, sir.
Your lordship, for a moment, kindly see, from their document, it is clear that there is no rule. What rule, my lord, why I am saying so? Here also they have tried to introduce the rule which is not in prevalent, because they have given the type copy. They are not giving the Xerox copy of that rule. Because no such rule is in existence in view of their committee report.
Mr.
Mila.
Ojha, it has already been taken note of by the apex court
Mila.
that there is in existence of a rule, number one.
Yeah.
Subsequently, there also, and once the rule is under the resolution of the society, it is there. How can you say that it's not
Then
there?
I will draw my lord's kind attention page 239 directly. Mila.
Maybe Supreme Court judgment, my lord. Internal page 17,
Part
paragraph
of-
11,
1-7.
What document
One
they have produced, my lord, before the Honorable Apex Court, that
Para
document
11,
also
para
produced
11,
before the
40.
Court here. And in
Yes,
absence of any,
Yes.
Yes, Mr. Padi.
My lord, Lordship may come to the internal page 17, para 14.
In the light of this
Eligible, my
case-
lord, Lordship may
Ah,
kindly
yes,
bear with
no, it's all.
in light of the facts and circumstances of the case and the submission made by the land council for both the sides, it can be concluded that the NWDA has framed its regulation, the CPF rules 1982, what we are disputing, and they were duly approved by the governing body of the NWDA. As NWDA is a autonomous body under the Ministry of Water Resources, now it is Jal Shakti. It has framed its own bylaws governing the employees. It has been time and again stated that the court must adopt an attitude of total non-interference and
Or minimal.
yes, interference in the matter of interpretation of the regulation.
Yes,
framed on
yes,
the
all right.
autonomous institution.
Yes, what do you want to further?
your lordship may kindly come to their affidavit.
We cannot go to the extent of saying that there was no rule. Now, because the Honorable Supreme Court has held that there is a rule, they have taken note of it. The submission which you are making will totally discard at the threshold.
Mila.
All right.
Oblige,
Yes.
Mila.
Any
Your
other
lord-
further submission if you want to
Yes,
make?
yes, my lord. Yes. Your lordship may kindly turn to page 6 of their further affidavit. My lord. That Xerox copy, type copy, they have given that in respect of that rule.
No, no, whatever they have given at this stage, it is a type copy, all right.
Your lordship may
Because
kindly
the
see.
Xerox copy was not
We
legitimate.
are telling you, will not allow a single submission on this authenticity of this rules. It has already been duly taken note of by the Honorable
Yes,
Supreme
yes,
Court. And
yes, my lord. Your
any
lordship-
further
your-
submission apart from 82 rules, if you are to make, otherwise you will reserve the order.
Yes, my lord. Your lordship may kindly turn to rule 1. Rule 1. B. They shall be deemed to have come into force on 15th July 1982.
Why? The reason being, the resolution has been taken in 1983 and the rule has come in 1982. Resolution has come in 1983. That is how it is deemed.
Milord. Then, my lord, I will draw my lord's kind attention, my lord, page 133 of the writ petition. My lord.
All right. 133.
Three, my lord. Only 2-3 documents I will show. This is dated 29/3/2019, my lord. They have given this information, my lord. Point number 1. NWDA is following Contributory Provident Fund Rules 1962 from its inception. But this is their document. Then I will draw my lord's kind attention page 238. 238. Then plus 238.
Yes.
Para 4. That this is document 16/5/2019. Their document. Para 4. That within that table में para 4. राष्ट्रीय जल विकास अधिकरण का कोई अलग से सीपीएफ नियम नहीं है. This is dated 16/5/2019.
We are dictating the order. This petitioners.
One more document, your lordship. One more, my lord. I humbly pray, my lord. Only one more document, my lord. One more document. Your lordship, this is my lord pension matter, your lordship.
Passed in OA number 50 of one so.
That document there, your lordship. May Kremlin with folded hand, your lordship, one more document.
In dismissing the original application, the original applications as filed by the petitioners were the retired employees of National Water Development Agency, that is the NWDA. It was established as a society in July 1980 and was registered under Society Registration Act 1986 and functioning under the administrative control of Ministry of Water Resources to carry out detailed studies, surveys, and investigation in respect of peninsular component of national perspective for water resources development. The basic grievances of the petitioner were that the Government of India, Ministry of Personnel, Public Grievances and Pension, Department of Pension, Pensioner Welfare, New Delhi, issued memorandum dated number so and so for changeover of the central government employees from contributory provident fund scheme to pension scheme, implementation of recommendation of Fourth Central Pay Commission. In the said OM, it was specifically stated that if no option is received by the date fixed, specifically requesting to continuing under the CPF scheme, the employees concerned will be deemed to have come over pension scheme. All the petitioners are the beneficiaries of CPF. The OMs, circulars, and orders passed by the Government of India from time to time are mutatis mutandis applicable to the employees of NWDA, and therefore the petitioner's case is that they ought to have been treated to have switched over to the pension scheme, and upon their retirement, they should have been paid pension and pensionary benefits instead of benefits flowing from CPF. Accordingly, they prayed for a direction to the respondents to treat them as employees under the Pension Rules 1972 in terms of the OM dated 1/5/1987 and to grant them pension and pensionary benefits with arrears and interest thereon. The opposite parties appear in the original application and filed their so-called counter affidavit, wherein it is stated that NWDA is society established in the 82 and it was registered under the Society Registration Act. The NWDA has its own rules and regulations for meeting the functioning of state of affairs. Bylaws 26A of NWDA stipulates that the emolument structures of the employees of NWDA will be adopted with the approval of the Government of India in consultation with the Ministry of Finance, bracketly Department of Expenditure. Bylaw 28 states that till such time as the agency frames its own working rules and regulations governing service condition of the employees of the agency, the rules and orders applicable to the central government employees shall apply mutatis mutandis to the employees of the agency, subject to such modification as may be made by the governing body from time to time. As for Rule 27A, the governing body of NWDA society shall exercise all executive and financial powers of the society, including those vested, public ought to be conferred on it by or under any statutes subject. Nevertheless, in respect of expenditure to such limitation as the Government of India may impose from time to time. It appears that during the hearing of the uh, original applications, the Learning Tribunal uh, found that similarly placed employees of NWDA approached the CAT Principal Bench New Delhi in OA number 2037 of 2008, which was allowed by the order dated 8 to 2010. And the respondent department challenged the said order of the tribunal before the Delhi High Court in WPC number 3197 of 2010, which was disposed of by order dated 6/1/2011. And the Delhi High Court has been pleased to hold uh, as follows. Quote from paragraph number 20 at running page 54, internal page 30, entire paragraph of 20. It appears that in compliance of the aforesaid order, the respondent department considered the issue relating to the grant of pension and pensionary benefit, but the same was rejected by OM dated 24/5/2013. The aggrieved employees of NWDA filed SLP C number 3106-3107 of 2012 and SLPC 20425/20426 of 2011 before the Honorable Supreme Court, which was dismissed. And the holding as follows. Quote the relevant paragraph of the Honorable Supreme Court order, which is at page number 54 and paragraph number 14, 15, basically entire paragraph. It further appears out of paragraph that one of the employees of NWDA, namely Sri Rohit Kumar Sethi, filed ON number 4242 of 2018 before CAT Principal Bench, New Delhi, praying for grant of pension and pensionary benefits. The tribunal, placing the reliance on the decision of the Honorable Supreme Court, dismissed the said prayer by order dated 11/9/2019. The Central Administrative Tribunal, after carefully examining the issues involved in all the cases and argument placed in support thereof with reference to the bylaws of the NWDA, vis-a-vis the decision of the Honorable Supreme Court in SLP number so paragraph 11 mentioned. Also the case filed before the Central Administrative Tribunal Principal Bench, New Delhi by Rohit Kumar Sethi came to hold that there is no substantial grounds to differ from the view already taken in the in those cases, especially in view of the clear-cut finding of the Honorable Supreme Court that the employees of NWDA are governed by NWDA CPF rules 1982, the OM dated 1/5/1987 is not applicable to them, and that the employees of NWDA are not central government employees at par with their counterparts, and hence their claim of parity with the central government employees was defeated, and accordingly the original application was dismissed. When the matter was taken up first on 11/9/2024, submission was made on behalf of the Land Council for the petitioners that though in the decision rendered by the Central Administrative Tribunal, Cuttack Bench, Cuttack, in way number 50 of 2021, that employees of the NWDA are to be governed by National Water Development Agency Contributory Fund Rules 1982 and not Contributory Provident Fund bracket with India Rules 1962, but NWDA has not framed any CPF rule 1982, but such rule is not in existence, and therefore the petitioners are to be governed by CPF rules 1962. Accordingly, we asked for specific instruction to be obtained as to whether there is any such rules, namely National Water Development Agency Contributory Fund Rules 1982 or not, and if it is in existence, to produce the copy of the said rules. Accordingly, the learned Deputy Solicitor General has produced before us the aforesaid rules of 1982. Not only that, today during course of hearing, the learned Deputy Solicitor General has brought to the notice of this court the judgment of the Honorable Supreme Court in civil appeal number so and so, where in paragraph number 40, the Honorable Supreme Court has taken note of 1982 rules and has been pleased to hold that it can be concluded that NWDA had framed its regulations, the CPF rules 1982, and they were duly approved by the governing body of NWDA. As NWDA is an autonomous body under the Ministry of Water Resources, it has framed its own bylaws governing the employees. It has been time and again reiterated that the court must adopt an attitude of total non-interference or minimal interference in the matter of interpretation of rules framed by the autonomous institution. Therefore, in view of the rules produced before this court by the learned Deputy Solicitor General, so also the observation of the Honorable Supreme Court in the aforesaid civil appeal number so and so, we are not inclined to accept the submission made by the learned counsel for the petitioners that the NWDA has not framed any has not framed National Water Development Agency Contributory Fund Rules 1982. Accordingly, after going through the impugned order passed by the learned Central Administrative Tribunal, and after hearing the learned counsel for the petitioners, so also the learned Deputy Solicitor General, we find no infirmity or illegality in the impugned order. Accordingly, the original application stands dismissed. Writ petition stands dismissed. Same order.
One request, my lord, let's be conjointly taken to paragraph 14 and 15 is better.
No, it's taken. It will be taken. Earlier you have mentioned it, 14 and 15.
Yes,
because 15, 16 are also, in 15 they have given that it is not existing.
Yes, next.
Passenger seat, my lord, concerned counsel.
Yes.
Item 2.
Please, your lordship. Last time, your lordship, item B told that Jawan lordship ordered 17/12/2024. Last order 6 mechanism. Last order, your lordship, 17/12/2024.
Last agreement, lordship directed to the whether Kochidabano is under the forest or not. On that respect, we are taking the instruction that there is no such notification has been made, but we are not giving the written report.
What is this office of Tahsildar?
They are saying that there is no such notification has been made on that respect.
No, what this flag X account?
That is how the notice they report they. Thereafter, my lordship passed on order 17/12/2024, mentioning that.
No, just come to that order. Let us please place that order 17/12/2024.
My lord.
Have you got the copy of that order? Please place it.
The order, lordship, the matter is second of in pursuance to the order dated 28/10/2024. London Council for the State has produced the written instruction dated 30th/11/2023 Tahsildar Bhubaneswar, wherein Section 2(3) of the Odisha Communal Forest and Private Land Provision Alienation Act or so and so Section 4 of the said Act have been quoted. It is mentioned here in that on verification it was found that the school leasehold land pertaining to Khata number so and so comes under the DLC list of for that district, and the school land comes within the forest land of Kochi for the district. It is further stated therein that this classification of the land Kochilabana may be treated as forest land and prima facie grant of lease without attending NOC from the Government of India as per the Forest Conservation Act 1980. His objection of the written instruction is taken on record that a copy of the written instruction is of the implementation for questioner. Well, it is pertinent question referring to the section 2C of the report act, but whether the land appertaining to Khata number so and so, plot number so and so, Moja so and so, has been declared to be a forest land by notification of the state board, and then council for the state fixed some further time of detailed instruction in that aspect has been for the matter case on 30th/1/2024. I want to reiterate your lordship order 28/10/2024, the initial order. Lordship formulated the reason of the order first 1, 2, 3, 4, the ground of rejection by the agents. The last I want to place in the para. London Council, second page of the order. London Council for Picture submitted that the London ATM Bhubaneswar has considered the revision case so and so have found that lease suffer from different effects inter alia. Classification of land in the Sabit Arwa is Kochilama, which comes under the forest land, but the London for the Tahsildar on 23/7/89 has mentioned in the order said that classification has been changed from Kochilama to Puratanpati and mutation case so and so has been accordingly corrected. As per the Forest Conservation Act 1980, the Tahsildar is not competent to sanction the forest land without obtaining NOC from the Government of India. It is the contention of the Learned Council for the petition that there is nothing in the Forest Conservation Act that Kochilabana comes within the forest land. Learned Council for the take some time to discuss in the matter plan.
Yes.
I humble summon if there is no instruction, let them so with an affidavit so that I will prepare myself. And another question in the next I forgot, Lordship, I have a glance. Our
So, Mr. Naik, when we passed the last order, we put a pertinent question that whether this land appertaining to this particular piece of land, Moja Swansu, has been declared to be a forest land by notification of the state government, okay, or not. So if you say that there is no such notification, then your oral submission would not do. You file an affidavit by a competent officer so that we'll take note of it. Yes. By mere submission, you say something would not be proper. File an affidavit. By next week, give him a copy. All right.
We'll also have a glance to the latest judgment.
That's all right. We are just let him file the affidavit or we'll hear and come. Order comes. As for order dated 17/12/2024,
several such orders are there, no? It has far-reaching consequence. Several orders are there on the basis of this. We have to.
We put a pertinent question referring to 2C of the Odisha Communal Forest and Private Land bracketary Prohibition of Alienation Act. As to whether the land appertaining to Khata number 343 and plot number 41 of Mauja Samsundarpur has been declared to be a forest land by notification of the state government. Stop. The London Council for the state took time to obtain detailed instructions in that respect. Today, the London Council for the state submitted that he has obtained instruction that there is no such notification issued by the state government declaring Khata number 343 and plot number 41 of Mauja Samsundarpur to be a forest land. Stop. Let the Land and Council for the state file an affidavit in that respect by a competent official of the government. Matter be placed in the week commencing. Ara saptah rakhiyo. Now you want one more week.
1 week.
Acha, list this matter in the week commencing from 27th of January 2025. A copy of the affidavit be handed over to the Land and Council for the petitioner in advance. All right? Yeah.
Item 3.
My lord, on behalf of Mr. Pitekar is so matter में kindly adjourn.
You want adjournment. A mention is made on behalf of Mr. P.K. Kaur for adjournment on the ground of his ailment. List this matter 27/1/2020.
Item 4.
My lord, I am for item 4. I am for item 4.
Yes.
There are 3 matters. The first matter is covered by your honor's direction dated 7th October 2024 in WPC number 24949 of 2024.
The council hurry the order which we passed.
249 in
No, what is the
WPC.
order? Kindly hand over a copy of the order.
I mean,
Why have you
BC.
not annexed it? What is the number you say? Please tell us once again.
WPC number 24949
949
949 of
of 2024
2024
dated 7th October 2024.
7th October 2024. Eta bhar kolo.
And the another 2 matters.
Just a minute. ସବୁ ଜିନିଷ ୱେବସାଇଟରେ ଆପଲୋଡ କରୁଛି ଆପଣ ବାହାର କରିବେନି ତାକୁ ପୁଣି WPC ବାହାର କରନ୍ତୁ ତାପରେ ହେଲା ନମ୍ବର ଦିଅନ୍ତୁ 4949 2024 ऑर्डर डेटेड होची 7/10/2024 हाँ सर क्लिक कर दिया तार कॉपी टे बाहर कर दिया So same order is to be passed.
My lord.
And here is also Collector Dhenkana.
My lord.
Opposite party number 3.
My lord.
What about these connected 2 matters?
Another 2 matters, similar order of writ petition number 24661.
24661.
24661 of 2024. Order dated 3rd October.
3rd October. This is September.
WPC 31280 2024. है ना তাড়াতাড়ি অর্ডারটা দেখবে খালি চেক করে দেবে সে কোনদিন ঢাকানা কালেক্টর অপোজিট পার্টি নম্বর 3
It's there.
বা তারপরে নেক্সটটা হচ্ছে আউট অফ আর কোন
24661
নেক্সটটা কেতে
24661
4661 of
of
24
2024.
Order dated 3rd October.
order
Third
dated 3rd October 2024 ভারত
Yes, madam, they are claiming that compensation.
Yes,
Let
on
us
the
see that.
order act.
here also collector Dhenkanad
My lord,
opposite party number 3
my lord.
এটাও দিলাম না
So other two matters are like that.
WPC
My lord.
number C1283 of 2024 outer one
3185.
31859 of 2020 same order pass all right
Obliged.
Item 5,
Thank you. So, my lord, and we are file repeat to the representation to the Tasla to collector under Annexure 2 thereafter Annexure 3, my lord, the assistant examiner body irrigation division replies to the reported to the superintendent Jarka irrigation division admitting the fact that it is to intimate and placing it is to intimate that
where are you placing
Annexure
Three.
run page 28.
running page 28
Right.
yes
It is to intimate that the river embankment of the Brahmani right near Islanpur Mulda is constructed at 30 years. The TRE is constructed to protect the floodwater. The total river embankment under Islanpur Mulda is constructed over private land through the verbal consent of the landowner. During verification of site, it is found that land around 1 acre 34 pounds of land is Govindchandra General Petitioner of village Islanpur is under Mayapur of Mirzapur TRE. The embankment is constructed without any compensation to the landowner. Hence, necessary instruction may please be given to the further course of action towards the compensation of land. As you lots of know, sir, collector is the authority as per previous act.
no this particular letter is in your favor
Man,
so what action they
What
have the
action?
superintending engineer
they have
what
not
action they have taken
not taken any action.
your representation was also to the superintending engineer
Right, to collector to superintendent.
no now this reply has been given to the superintending engineer
Right,
as per annexure 3 so obviously superintending engineer has to take the follow-up action
Right,
according to you that has not been taken
not taken.
we are directing him to take
Right,
it
who believe?
all right the writ petition has been filed by the petitioner Govindchandra Jena the following prayers, 4 the prayers, Roman 1 and 2 mainly. The London Council for the petitioner submitted that the petitioner filed a detailed representation to before the opposite parties
Under answer 2.
under annexure 2 praying for compensation. And after receipt of the same, a query was made by the Superintending Engineer, Jarka Irrigation Division, Jarka, by memo number 3971 dated 23/9/2024. And accordingly, the Assistant Executive Engineer for Irrigation Subdivision replied to the same and wherein it has been mentioned that during verification of the site, it was found that the land acquired was around 1.44 acre of the petitioner of village Isanpur, PS Bari Ramchandra Place, Jajpur, which was under Mayapada, Mirzapur, TRE, and the embankment is constructed without any compensation to the petitioner. Thus, from the later under Annexure 3, it is clear that even though the land of the petitioner has been acquired for the purpose of construction of embankment, but he has not been paid any compensation. It is the contention of the Land Council for the petitioner that after receipt of such letter from Assistant Executive Engineer, the Superintending Engineer bracket opposite party number 5 has not taken any follow-up action in disbursing the compensation amount to the petitioner, and therefore appropriate direction be issued in that respect. Land Council for the state has no serious objection to the submission made by the Land Council for the petitioner. Considering the submission made by the Land Council for the respective parties, we dispose of the representation, the petition, directing the opposite party number 5 to take a decision in the matter of payment of compensation to the petitioner on the basis of Annexure 3 dated 18/10/2024 of the opposite party number 6 within a period of 3 months from the date of production of the certified copy of the order, and communicate the result thereof to the petitioner within 2 weeks of the taking the decision. We have not expressed any opinions for disposed of. Yes, next.
Item 6.
May it begin, Lord. The matter is related to various matters. The petitioner is the process server. He is working under the Dungurupalli TMXC also. Let a report be called for from the registered administration, High Court of Orissa, which is to be placed before the on such and such date. They give a date, list this matter on such and such. Yes, next.
Item 7.
The petitioner has great first one, so they are put in the list. Yes, next.
Item 8.
May I please have 7.
Item 7.
Yes, item number 7. Nobody is there. Pass over.
Item 8.
May I please, Madam, on behalf of Mr. S.K. Madam, I now declare Madam, the read the contribution filed for seeking direction to opposite party number 3
Consider the events of your representation is under Annexure 3. Annexure 3, madam. That is 26/10/2024. You have not received any communication from the concerned authority, right? Another prayer is, madam, the civil suit is pending before the Leonard Civil Judge Senior Division Jharsuguda. Yeah. That is the partition suit of the present petitioner and the opposite party number 4 to 6 here also. Yes. My humble prayer is, madam, during pendency of the civil suit, madam, the amount should not be disposed, madam. Not dispose of representation, dispose of. Annexure 3 is the representation. Yes, time limit there. Next.
Item 9.
My petition of challenging the illegal arbitration of the opposite party is an award the less compensation amount compared with the government measure of value.
Your representation is pending before opposite party number 3.
Opposite party number 2.
Zone officer.
Zone officer.
Officer come LA collector.
Opposite party number 2.
Opposite.
And in all these writ petitions, your representation is Annexure 6.
Annexure 6. Okay. And the similar type of matter also disposed.
Please pass on. You have the agents, you only dispose of that.
Item 10.
And on behalf of item 10, the representation of petitioners may be considered.
Annexure 8 though?
Yes, madam. Similar type of order.
ଆପଣଙ୍କ ନାଁ କଣ?
ଗୌତମ ପଟ୍ଟନାୟକ madam.
ହଁ ଗୌତମ
ପଟ୍ଟନାୟକ.
ଆପଣ ପାୱାର ଅଛି?
ନାଇଁ ସେଇଥିପାଇଁ କଣ?
ତା ନାଁଟା ଲେଖି ସେ ଯୋଉ ବାବୁଙ୍କ ନାଁ କଣ? Mr. Counsel, what is your name? ନାଁ ଅଛି? ମନୋଜ ଓଝାଙ୍କ ନାଁ ଅଛି। ଆଜିରେ ସେ ବାବୁଙ୍କ ନାଁ ଗୌତମ ହେଲା।
My lord, I'm sorry to interrupt, my lord. Item 8 it is disposed of, my lord.
Item 8, it has been disposed of as a representation କଣ ଗୋଟେ Annexure. ଆପଣ ଇଏଟା ଲେଖିଦବୁ ଆପଣ ଯୋଉ
sir, my lord, sir.
Union of India Central Government Council. Yes, next.
Item 11.
This is the second brief application of the present petition. WPC 4797. Reprehension direction has been given to show the reprehension matter. Where is that order? Order annexed. No. Order annexed. कौन ହେଇଥିଲା representation को आइतला dispose of करिया ପାଇଁ को representation ଟା where is that earlier representation ନାହିଁ ବର୍ତ୍ତମାନ କଣ ଆଉ ଗୋଟେ representation ଦେଇଛନ୍ତି କଣ ହେଲା ତାର result କଣ ହେଲା result ହେଲା ଯେହେତୁ ସେମାନେ ଆମକୁ ଚାକିରି ଦେଇ ନଥିଲେ ଆମେ 20 ଲକ୍ଷ ଟଙ୍କା ହଉ ଯୋଉ ଆଗରୁ ଆପଣ ଗୋଟେ representation ଦେଇଥିଲେ ସେ representation consider ହେଲାନି ବୋଲି ହାଇ କୋର୍ଟ କୁ ଆସିଲେ ହାଇ କୋର୍ଟ ତାଙ୍କୁ direction ଦେଲା representation dispose of କରିବାକୁ ସେ representation dispose of କରି କଣ order pass କଲେ ସେମାନେ ସେ order କାଇଁ କିଛି ତ ଦେବେନି Annexure 2 minor. Annexure 2. Annexure 1 is the sorry, madam. Annexure 1. You pay para number 5. Annexure 1 ta kon? It auto kon copy of the letter likha hai. They disburse the amount, madam. 15 lakhs, madam. That's because they not
ଆପଣ କରିଥିବା ଦସ୍ତଖତ ଜଣାଯାଏ ଯେ ଆପଣ ନିଯୁକ୍ତି ପରିବର୍ତ୍ତେ ଆଜି କ୍ୟାଶ ପ୍ୟାକେଜ 15 ଲାଖ ପ୍ରଦାନ ନିମନ୍ତେ ଆବେଦନ କରିଛନ୍ତି ଆପଣଙ୍କୁ କ୍ୟାଶ ପ୍ୟାକେଜ
compensation amount granted madam 15 lakhs madam. Our prayer is madam as because they not appointed any of the family members for that reason we have demanded rupees 20 lakhs madam. That represents in WPC number.
Oh.
I would file ଦେଇଛନ୍ତି Annexure 4 is the second representation for 20 lakhs.
That means that one has been considered, but they say that 15 lakhs have been deposited. You expect more, 20 lakhs.
Yes, 20 lakhs. That is for that you have submitted another representation. That is Annexure 6. Annexure 4. And 4. Total is pura 2022 ର. Yes, madam. That is Annexure 4. 22/12/2022. ତାପରେ କଣ ହେଲା
ତାପରେ ସେମାନେ ଗୋଟେ ଚିଠି କଲେ annexure 5 ରେ ଯେ ଆମେ 10,99,000 ଦେଇ ଦେଇଛୁ ଆଉ ରେଷ୍ଟ ଆମାଉଣ୍ଟ ଆଉ ଦେଇନାହାନ୍ତି ସେମାନେ. Thereafter again we have filed an application to the collector annexure 6 madam.
ବର୍ତ୍ତମାନ ଲାଟେଷ୍ଟ କୋଉଟା ପେଣ୍ଡିଂ ଅଛି କହିଲେ?
Annexure 6
Annexure 6 ଟା dispose. Annexure 6 to be disposed. Yes. Time limit they will. Yes, next.
Item 12.
Under section 28 application is pending before the appeal party number 2. Similar order I have also annexed.
Annexure 3.
Madam.
ଆଉ ସବୁ ସମାନ ଅଛି ନା କି ଯେ ପଟ ସେପଟ ହବ ଖାଲି କେସ୍ ନମ୍ବର
Annexure figure. Case number.
केस नंबर खाली यही हो. अच्छा. Annexure 3 रे जहाँ अच्छी केस नंबर का जो चेंज है पार्टी में केस नंबर थोड़ा सा चेंज है और बाकी सेक्शन.
Item 13.
Petitioner challenging the order passed by the Lawrence Central Administrative Tribunal dismissing the original application which has been filed challenging the rejection the petitioner from the promotion which has been given to him before the reevaluation of the marks on representation of the appeal number 5.
No, you are challenging the annexure 1.
Yes.
And what was your prayer before the Lawrence Central Administrative Tribunal?
Lawrence Central to pass the order dated 25/4/2024, which is under annexure 8 million, page 47, where the re-evaluation of marks of the promotion departmental examination has been revised and opposite 5, party number 5 has been selected and I have been removed. Annexure 8, page 47.
Please come to the running page 27, internal page 7 of the interim order.
Yes, madam. Yes, madam. Paragraph 5.
Paragraph 6.
Yes, madam. As regards merits of the matter on re-evaluation of the answer sheet, the respondent number 5 was found to have scored higher marks in the test than the applicant is not in dispute. May I submit one thing, Miller? During pendency of the original application, this revision has been taken place.
Re-evaluation has been taken up.
I have not challenged the re-evaluation, that is the admitted fact. But as per the rule 20 of the Master Circular number 31, the Railway Department, it is saying that before removal, I should have been given an opportunity of hearing for explanation. That has not been provided to me. On that ground, I have for the central tribunal.
No.
The order
Who has asked for this re-evaluation?
opposite party not hiring.
In another case?
Now, in this case, as I have been selected, there are
No, re-evaluation has been asked for by the opposite partner 5 before the authority.
Before the authority.
And the authority re-evaluated it.
Yes.
And while your matter was pending in OA, after the re-evaluation, you have been removed and he has been taken. You have not been afforded any opportunity.
Fortunately.
That is your case.
Yes. The court has also dealt with it. The order of re-evaluate the answer sheet was also seen to have been done in terms of the rules and by the order of the competent authority. The modified list was also duly communicated to the applicant, but he did not make any representation if he was having any grievance on the same. The applicant also neither challenged the authority of the respondent for re-evaluating the answer sheets of the respondent number 5, nor has challenged the valuation or re-evaluation made by the committee by the order of the competent authority in terms of the rule. It is well settled law that the authority is competent to rectify its mistake as per rules and laws. In view of the above, it cannot be said that no opportunity was allowed to the applicant. However, the applicant did not produce any record that he had secured more marks than the respondent number 5, or the marks on re-evaluation given to respondent number 5 was in any manner not correct. In the circumstances, giving opportunity to the applicant would have been an empty formality and non-compliance of which cannot be faulted with, which is well supported by the law laid down by the Honorable Appeals Court in the case of Punjab National Bank versus Manjit Singh, 2007, 1 SCC L&S 16, wherein it has been held that the principle of natural justice were also not required to be complied with, where the same would have been an empty formality. Thus, the court will not insist on compliance with the principle of natural justice in view of the binding nature of the award. If only one conclusion is possible, a writ would not issue only because there was a violation of the principle of natural justice. In the above facts and circumstances of the case, we found no substance on the submission of any counts of the appeal, so as to interference in the matter.
So where is that order on the basis of which reevaluation was made? Where is the order on the basis of which reevaluation of the answer sheets of respondent number 5 was made?
Annexure 8, page 47.
Annexure 8.
Yes, Kunja.
Just a minute. No, ma'am. We want that. What is that order? You said that this respondent number 5 approached the Central Administrative Tribunal in some matter.
No,
Then how?
respondent 5 approached the authority for reevaluation.
He has approached the authority.
Acha.
Yes.
And the authority, by virtue of Annexure 8, has disclosed that the petitioner has secured less mark than the respondent number 5. And accordingly, he has been given the promotion.
So if that Mishra, Pratyusha Mishra, she asked for reevaluation and the authority considered it, reevaluation was made. Why you will be given opportunity of hearing?
As per Rule 20, if one person is selected for promotion, when you will remove, he should have given an
No, that is a different matter. But at the time of reevaluation, why you will be given opportunity?
Not at the time of reevaluation.
So,
at the
okay.
time of remove from the panel.
Okay, that you say.
Yes.
So then what happened then? After this order was passed or re-evaluated, then what happened?
And then Annexure 9 will see.
Okay.
They modified the rule. I removed me from the training. I have already crossed the 6 month training. At that time, they include the Pratyusha Mishra in the panel and they remove.
That is modified provisional list.
Yes.
All right. Notice. The petitioner Sachidananda Kumar. Kumar na Kumar?
Kumar.
Kumar has filed this petition challenging the order dated 26/11/2024 of the Land Central Administrative Tribunal, Cuttack Bench, Cuttack in way number 260 of 260/00281 of 2024. It appears that the petitioner approached the Land Central Administrative Tribunal challenging the order dated 25/4/2024 under Annexure 8, wherein the senior DPO Sambalpur bracket ray opposite party number 3 decided to remove his name from the panel of JE bracket ray P way in level 6 bracket ray GP 4200 against 20% LDC in civil engineering department with the replacement by one Ms. Pratyusha Mishra, TM hyphen IV public SBP. It was the contention of the Land Council for the petitioner before the Land Tribunal that the petitioner appeared in the written examination conducted on 25/2/2023, a result of which was published on 11/7/2023, in which his name was placed at serial number 156 and the name of opposite party number 5, Miss Pratyus Misra, was placed at serial number 234, and accordingly a provisional panel for promotion was published on 26/6/2023, where the name of the petitioner was placed at serial number 4, and then the petitioner was promoted to the post of JE bracketary PUA on 26/9/2023 and sent for training course. And he was then sent for pre-promotional training, and on completion of classroom training, he was detailed to undergo field training for 2 months from 4/3/2024 to 3/5/2024. However, an application was filed by the opposite party number 5 for reevaluation of her marks, and by order dated 25/4/2024, the marks of opposite party number 5 was revised, and accordingly the name of the petitioner was removed from the panel of JE bracketary PUA. It is the contention of the Land Council for the petitioner that no notice or opportunity of hearing was provided to the petitioner. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. The Union of India accepts notice on behalf of Mr. Padhi for all these.
Copy number
Copy
1,
number
2, 3, 4,
1 to 4.
1 to 4, yes.
Extra copies of the writ petition be served on the Land Council, Deputy Solicitor General. So far as private opposite party number 5 is concerned, requisites for issuance of notice by state post of delivery shall be filed within 1 week. Matter to be listed 4 weeks after. Counter affidavit, if any, be filed in the meantime. Yeah.
Item 14.
Odisha government land settlement matter in lot in that order in the past. Annex 3 sanction.
Order HE, secret fasting.
Item 15.
Number 1 is the wife. Issue number 2 is the son of the original borrower. In the year
You are challenging 13/4 notice.
13/2, madam.
13/2.
Because after the death of the original borrower, this paper
No,
publication-
13/2 notice.
Madam,
This is 13/4. Thereafter, this advertisement has been made.
my lord, nothing have been solved on the original borrower who died
Go to the
2023.
go for the alternative remedy. That is
My lord, my grievance here is the original borrower has expired. Death certificate annex 2, your lordship may kindly see.
Mr. Chinchani, whatever you want to place before your DRT, will consider all your swans.
My lord, I am aware of that, but
Yes.
it is a question of alternative
That
remedy.
can so be whatever you say, principle of natural justice, everything can be dealt, disposed of for the in light of this decision. Yes, next.
legal hairs were required to be put at a notice.
Yes, next item number 16.
Item 16.
Madam, in this case, the acquisition of land of the petitioner was challenged before your lordship in restriction number 20921 of 2015. I have quoted the order wherein it was disposed of, directing that that cannot be interfered with. I can pursue my remedies. Your lordship may kindly turn to page 5, paragraph 7 of the order. My lord, in the above view of the matter, Mr. Amitabh Das, learned counsel for the opposite party NHAI, undertakes that the petitioner shall be paid the compensation amount which has been deposited before the competent authority within a period of 15 days hence. If any claim survive with regard to enhancement of compensation, it is open to the petitioner to pursue his remedy before the appropriate forum in accordance with law. Thereafter, I moved an application before the competent authority in arbitration miscase number 1 of 24. The learned arbitrator kept this matter in abeyance, saying that unless you receive the money, I will not hear the matter. Receiving a money is a different thing. I may receive, I may not receive. They can deposit in the.
No, what is the arbitration miscase number?
1 of 24.
इधर नहीं तो
para page 17 में नहीं.
It is there in page 10, man.
अच्छा, started out 1 of 24.
Yes.
So,
certified copy of the order.
What is the status of this case?
He has kept in abeyance. Your lordship may kindly see at page 16.
16.
On careful perusal of the case record and hearing both the sides, it is concluded the case land has been acquired and will be used for extension of road. As regard to payment of compensation amount, pursuant to the order of the Honorable High Court, the petitioner himself has denied to receive the same with a plea that he is moving Honorable Supreme Court. So the Supreme Court affirmed the order of this Honorable Court. There is no dispute on that my land will go. As per the order of the Honorable High Court, the petitioner has to receive the compensation first. Thereafter, if any claim survives with regard to enhancement of compensation, amount of the petitioner may pursue his remedy before appropriate forum of law. In circumstances such, the petitioner has not received the compensation amount. Pursuant to the case of enhancement of compensation amount, no merits no consideration, hence the case is kept in abeyance. But if I don't receive and I'm pursuing my remedy for enhancement, he has to decide whether I will get an enhanced compensation or not.
Now, what is the mandate of law? What is the provision?
There is law is
At what stage you can move? Whether after receiving or
no, there is no such.
Kindly read that.
Yes.
Yes, sir.
Let us see the act. Whatever it
Yes. 3G says
is there.
National Highway Authority.
NHAI.
Here, who is appearing for the
Mr. Amitabh Das usually appears for National Highway.
copy region?
Copy copy.
You are appearing.
Now they have appointed me as the standing counsel to receive the advance copy. NHM. Then he let him copy.
But here, I have no dispute with NHM. My dispute is entered with the arbitrator.
You have made a party him.
Yes, I will give it.
You just give a copy. It will be taken off. What is that?
What I humbly submit, may I submit? Here, with respect to my landed senior submission, this is a G5 order, which is purely coming under the scope and ambit of Arbitration and Conciliation Act. So, my place, 3G6 says that it would be constituted as an arbitration proceeding. Therefore, any order passed by the arbitrator has to be challenged by the competent civil court. That is the commercial court.
He has not passed an order.
He has not passed the order.
He has kept in abeyance.
No, subject BC 2013 Act has been applicable to NH Act with effect from 1/1/2015. There is a provision in the new Act that you have to receive compensation, then you file the reference application for enhancement.
That is what we are asking for. Where is it?
60, sir, I think 64.
64.
Refer to the authority.
Any person interested
Yeah,
who has
just a
not
minute, just
accepted the award,
64.
my lord, the RSPTL 2013.
64. Any person interested
My lord,
who has not accepted Pujan?
not accepted the award.
Huh. Yes,
Mean by writing application to the collector require that the matter be
Exactly.
referred to the collector for the determination. Currently, as the case may be, whether the subjection be pursuant to measurement or pursuant to matter, provided that the collector shall within a period of 30 days from the date of receipt of application make a reference to appropriate authority, provided for that.
The 64 is a condition where he has not accepted.
I matter, sorry, madam. I'm bringing matter. No, there is provision.
No, you are not referring to the correct provision.
Before filing reference, he has to receive the compensation. Anyway, matter, not see, I will take it.
No. But he here,
So what is your prayer for reference?
the
No,
prayer.
my prayer is let him decide my arbitration petition. But he cannot put a rider that because you have not received, I will not hear it.
This is RR policy 64 is. In NHAI, you have.
This is NHA.
NHAI is a arbitration. Collector
NHA
arbitrate.
provision regarding receipt of compensation from first and thereafter file. NHA simply says whenever who is person is not satisfied with the compensation awarded by the competent authority, then he has to file application under section 3G5 before the arbitrator and collector.
Yes, that is what he
That
has
is not
filed.
filed. But what the arbitrator has done here, now he is saying that you have not
No,
received the
that he cannot.
compensation. But the 2013 Act, there is provision. NH Act, there is no such provision. Then he had to prove it because as per C section, Mr. Behra has submitted matter. As per section subsection 6 of section 3G, then the Arbitration Conciliation Act has to be applicable to each arbitration matter. Therefore, the collector has to hear it. Because my lord, he has
And in
not.
fact, my lord, I have moved the
State it
arbitration.
abeyance, that is his grievance. So
Yes, ma'am.
you take notice, so let us see.
Yes, my lord.
The petitioner Rajesh Kumar Agrawal has filed this application, writ petition for quashing the order dated 13/11/2024. Passed by the collector and arbitrator Bargot in arbitration with case number 1 of 2014.
My lord, it is 1 of 2024.
2024.
Yes, my lord can see at page 10.
Wait. 1 of 2020. It appears that the claim of the petitioner is that what is this RT?
My lord, recorded tenant.
He was the recorded tenant of the scheduled land and having the same in possession, which was acquired by the central government for the purpose of widening and construction of 4-lane national highway. The opposite party assessed the compensation payable to the petitioner under section 3G of the NHI without taking into consideration the market value of the land, damages and injuries sustained by the petitioner in spite of the grievances raised by him. The petitioner's arbitration in this case was admitted on 28/8/2024 and the London collector and arbitrator opposite party number has been pleased to hold that so far as the payment of compensation amount pursuant to the order of this court is concerned, the petitioner himself has denied to receive the same. And as per the order of this court, the petitioner has to receive the compensation first, and thereafter, if any claim survives with regard to the enhancement of compensation amount, the petitioner may pursue his remedy before the appropriate forum as per law. And since the petitioner has not received the compensation amount, the opposite party number has been pleased to hold that his case for enhancement of compensation amount merits no consideration and accordingly kept the case in abeyance. Query that order of this court which was passed earlier.
My lord, I have quoted in page 5 of the writ application. My lord, it starts, sorry, my lord, it is at paragraph 4, page 3, running up to page 5.
The London counsel for the petitioner, Mr. Bose, submits that in the operative portion of the order passed by this court on 12/7/2023 in WPC number 20921 of 2015, it has been observed that the London counsel for the NHI undertook that the petitioner shall be paid the compensation amount which has been deposited by the competent authority within a period of 15 days hence. If any claim survives with regard to the enhancement of the compensation amount, it is open to the petitioner to pursue his remedy before the appropriate forum in accordance with law. The contention of the Land Council for the petitioner is that even if the petitioner has not received the compensation amount, that does not debar the collector from arbitrator Burger to consider the enhancement of the compensation amount, and there is no such condition precedent in the National Highway Act 1956 itself that before entertaining a prayer for deciding the enhancement, whether a party is entitled to receive the enhancement of the compensation amount, the party should receive the compensation amount first.
Determined under 3G.
Determined under section 3G of 1956 Act. Stop. Issue notice on the question of admission indicating therein that the matter shall be disposed of at the stage of admission. The Land Council for the state accepts notice on behalf of the opposite party number 2. Extra copy we served on him. So far as opposite party number 1 is concerned, you undertook.
He has made a NHA as a party because as per law he is NHA listed party.
Yes, not.
No. This land acquisition officer and the competent authority under NH Act Burger wish to appear.
After passing the award, then my Lord State Council may appear for them. Because after passing the award, he become functus officio. LO has no role. Only now the arbitration has to be made and the NHA has to defend the same. Since the NHA as per section 12 DB of the NHA Act, the necessary party, NHA has to be made a party here. Project Director P.S. Samarthi.
Acha, upon not I go them. So also submits that in a dispute of this nature, NHI is a necessary party, and the he has not been made added as a party. The Land Council for the petitioner shall file appropriate application for making the NHI as a party.
If your lordship permits oral prayer, if your lordship may accept, I can make him party and give it to him.
No, he had to be mentioned as a party number, opposite party number
Three.
3.
My lord, if your lordship.
No, orally prayer can interim application that
My lord, I'll file.
he has to file. Interim application is filed to make so and so the so and so be for passing necessary order. So now you file that application. Now, so far as these two opposite parties are concerned, the state can appear. State will appear for opposite party number 1 and 2. It has definitely only opposite party number 2 will appear. So he has instruction to appear for both the opposite parties. Tapir tanko submission ra karibe. Je submits that he is necessary party. At this stage, Mr. Bose submits that he will file an interim application to make that so and so NHI as one of the opposite parties. And for the state should be they're just coming within 2 days.
Item 17.
This is the second round of litigation before this honorable court by the petitioner. Earlier, the petitioners have approached this honorable court in a writ application, wherein they have prayed to proceed with the Land Acquisition Act 30 in the new act as the
Where is the earlier order?
below. That is, your lordship will find at page 31 under annexure 3, and the relevant paragraph would be para 9 at page 36.
Please place that paragraph
Below.
9.
Paragraph 9. In view of the above, since the land acquisition officer has prayed for leave of this court to proceed in accordance with the provisions of Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013 for acquisition of the plots, let him do so as expeditiously as possible so as to pass necessary hours and disburse the same in favor of the petitioner. The steps shall be taken by him within a period of 4 weeks so that the relief sought for by the petitioner can be granted. Needless to say, since the land has been acquired for the purpose of IDCO, the IDCO authorities are directed to provide necessary assistance so that the compensation amount can be disbursed in favor of the petitioners within the time stipulated. Now, what has happened below? Now, I have asked for the necessary information under the RPA Act, that what action you have taken. So they have replied me under annexure 5 series at page 43.
No, have you not received any compensation?
No. The land acquisition process has been started since 2002 million under the old act. Now, in the previous writ application, I have prayed as there is no award, so the new act will come into force, and you have to, my lord, pass the necessary notification.
Now you have filed your representation under annexure 8.
No, my lord, that is now redundant because they have now said that we have complied the order of this honorable, which was passed in 5/4/20.
Where is that?
My lord, I am stating that. Lordship may see annexure 7 series at page 48. What depths may I please lord? As page 48. In inviting a reference to the above cited subject, I am to say that late so-and-so of Haldiapadar, Barampur is one of the land users of project Offanagar complex at Haldiapadar. Now the compensation amount to be disbursed in adherence to the High Court
how
order.
this petitioner is related to finance?
My lord, he is also a petitioner. My lord, they are the legal heirs. They are the legal heirs.
Okay.
But now, lordship, in this pretext, I would like to take your lordship to section 24 for once.
No, just place it.
Complete it.
My lord,
Now the compensation amount to be disbursed in adherence to the High Court order.
Order dated 18/4/24 in connection with WPC number 20357 of 2016, filed by S.K.Sahoo and others.
Right.
Now, my lord, they have said that we have complied.
No, therefore you are requested.
Where are you going?
Therefore, you are requested come with legal aid certificate, bank account details, and Aadhaar card for legal aids of late Gopinath Sahu within 3 days of receipt of this letter for disbursement of compensation.
What happened then?
My lord, now I am saying that, my lord,
This is addressed to Pradeep Kumar Sahu and others.
My lord, Pradeep Kumar Sahu is one of the
son of late Gopinath Sahu. Yes.
Son of late Gopinath.
Then what happened?
My lord, now lordship may kindly see that annexure 5 series, wherein they have said that we have complied as per this form K, where necessary award has been passed. Under annexure 5 series at page 43.
No, this
After this, my lord, they have done nothing, my lord.
this you see, this was passed on this annexure 5 is dated 21/6/2024.
My lord.
Thereafter, this order was passed on 21/8/2024, and the parties were asked to just produce the legal aid certificate, bank account detail, and Aadhaar card, etc. And whether they produced before the authority.
My lord, I have represented before the authority by saying that this is not the award because you have never initiated the land acquisition proceeding under the section 11. My lord, this honorable court has directed them to process with according to the new act. Now, my lord, there is no notification as such because the old under the old act, the section 4(1) is now redundant. That has been lapsed.
No.
So there is no notification itself.
No. Where is has the authority stated that as per annexure 5 we are going to be awarded?
Yes, my lord.
Where is that?
That is, my lord.
No, annexure 7 doesn't say so.
Annexure 5 series, my lord.
No, Annexure 7 is the
Annexure
order that has been passed to directing you to produce the document and get the award.
My lord.
What is the award has not been given here.
Lord, I'm checking that.
How can you assess that this is the Annexure 5 series is the award?
Kindly come to page number 43 for a moment.
Yes, that is what.
That is the award they have passed. That is, they say that this is the award as per the.
So according to you, this is not in accordance with 13.
My lord.
Please come to Annexure 5 series.
My lord.
Come to page number 43.
My lord. Now, my lord.
Please come to page number 43.
My lord, I'm on 43.
You see, please come to column number 11.
My lord.
Which act is mentioned there?
My lord, that is
2013 act or not?
My lord.
How do you say that authority has not considered it?
At the top, my lord, may kindly see the land acquisition case number, that is not there. At column number 2, my lord, the date of declaration, that is not there. The date of notification, that is not there. Because the date of notification, they have never acquired the land.
No, what is your case?
My lord, my
If
case,
even if because the matter was pending and had not been disbursed,
my lord,
it is to be covered by 13.
13 acts.
So rightly they have covered you in 13.
No, my lord, they have to pass a necessary notification first. Then after the award comes to us. That is why I am getting, my lord. Lord, may kindly see for a moment section 24. What it is? Section 24 of the new act.
Speaks about the coverage.
Yes. May I please, my lord. Section 24, land acquisition process under Act number 1 of 1894 shall be deemed to have lapsed in certain cases. Clause 1, notwithstanding anything contained in this Act, in any case of land acquisition proceedings initiated under the Land Acquisition 1894, A, where no award under Section 11 has been made, then such proceedings shall be continued under the provisions of the said Land Acquisition Act as if the said Act has not been repealed.
No,
I am covered under this.
But on the face of this Annexure 5 series, it appears that they have passed this compensation in terms of 2013. As it appears, because it is clear there. Suppose you say that you are entitled to more, you are not satisfied, then the recourse is there under Section 64.
No, my lord, what I am submitting, my lord, they have to calculate the market value.
So why are you going in their intricacies?
No,
You
no,
see
this
the
is
result of it.
This is a statutory proceeding.
So who is challenging this?
My lord, I am challenging.
No, I think there is something behind this.
No, my lord.
No. Otherwise, why you are challenging this?
My lord,
They say that 13 rule has been followed.
I am also, my lord, affected by the market value.
No.
Why I am saying, my lord, Section 23 lord,
Then 64 reference is there.
No, 64 reference because the proceeding has not been initiated.
No,
as per the court direction.
don't go by that. You are going behind the order. You are going behind the order. First you go, you see this is the award that is going to be disbursed to you. So you will say there is no point in going to the notification. Then you go for the enhancement. That's all.
If there is no notification, how can an award have been passed?
That is the notification. Who says that? Who says?
Section 24 says.
Where from you say this? No, what is the background on which you say this? That there is no notification.
Because the previous order below of this honorable court.
Where is that?
My lord, I am saying that.
Where is this court asked for the notification? They asked for.
This court simply says that you decided in 2013.
That's
2013.
That's all.
Process has to be initiated. My lord, the process when this court said that the proceeding has to be initiated under the new act, then the entire proceeding, my lord, because there is no notification now. If there is no notification, there is no declaration. How can an award has to be passed? This award cannot be passed. And for this, Lordship may kindly see section.
You mean to say that now the notification should be on the basis of 13?
Yes, my lord.
Okay. No.
Because that has been lapsed, Lord.
No.
As per section 24.
No notification is required. That is how 24 has come into play. The 24 is kindly read where no award under section 11 of the Land Acquisition Act has been made. That means the notification is already there, but award has not been made.
Not been made.
Then all provisions of this act relates relating to the determination of compensation shall apply.
All provisions it says.
All,
It is
all
not necessary
provisions.
that again a fresh notification is to be issued.
fresh notification.
That is the law, my lord. Why I'm saying the market value has to be determined on the date
That
of
is different.
notification.
That you
That
can
is
always
different.
challenge.
That is different.
My lord, section 26 mechanism.
No.
Section 26 for a moment. Section 26 is determination of market value of land by collector. That is, my lord, after point number A, B, and C, there is a provision provided that the date for determination of market value shall be the date on which the notification has been issued under section 11.
Yes.
Now there is no section 11, my lord.
No. This is deemed. This is a deeming provision.
My lord,
You
this-
are covered under this.
my lord, this court has categorically said to the land acquisition collector.
No, that is
The land acquisition collector has deposed before this court on oath that there is no award as such. So we'll proceed according to the new act.
obviously
Yes,
because there is no award. You are covered under 24.
my lord, now the market value is assessed as per the new act, my lord.
Yes.
They have assessed
They
it.
have assessed it.
They have assessed it without, my lord, the hallmark of the new act is rehabilitation.
You
and
are
No, you have
correct.
a-
You are
No,
correct.
that is not
you have
there.
a ground.
This writ petition has been
You have a
filed
ground.
with so and so.
Then, my lord, if I have three minutes, for a moment,
Earlier
my
writ petition was filed, which was disposed of
Lordship, my-
by such and such
lord,
order,
pardon me, lord.
holding
I
like
pray
this.
for another date, my
It
lord, for
appears that
better
the
preparation.
considering the order of this court, the authority has passed annexure five series wherein the land acquisition award has been passed and taking into account the 2013 Act. And on 21/8/2024, also under Annexure 7 series, the petitioners were asked to come with legal heir certificate, bank account details, Aadhaar cards of the legal heirs of late within 3 days of receipt for disbursement of the compensation amount. The same, according to the Land Council for the petitioner, the same has not yet been done. As the compensation amount has not been determined in terms of 2013 Act. We are not inclined to accept such submission if the petitioners have not accepted the award and they claim that for enhancement of the compensation amount, the recourse is available under section 64 of 2013 Act. The petitioners can take this recourse accordingly. The petition is disposed of. Yes.
Item 18.
Limited care of the and the option purchaser and paying for disposal of the SA case which is pending since 2019. And the option also saw the copy.
Which is that SA case?
Pardon me, sir.
SA case number so and so.
Yes, so 112 of 2019.
In SA case, who is the petitioner?
Petitioner will have opposite party number 3.
Okay. In that case, notices have been issued.
Yes, yes, my lord.
You have entered appearance. All
Yes.
the pleadings have been completed.
Yes, my lord.
All right. You start to stand here, sir.
Yes.
This writ petition has been filed by the petitioner, Udala Srinivas, for a prayer for disposal of SA number so and so, filed under section 17 of the Surface IR. Before the
DRT.
before the DRT cutter.
DRT cutter.
Before the DRT cutter. It is the contention of the Land Council for the petitioner that the petitioner is the auction purchaser and the essay was filed by opposite party number 3, Renuwala Panigrahi,
was borrower, man.
who was the borrower.
Man.
And in the said case, notices have been issued, and the petitioners who also the opposite party number 2 have already entered appeal.
You have filed IA, no? You have filed a IA.
IA for early disposal.
Early disposal.
Early disposal.
He submits that an interim application has also been filed by the petitioner, by IA number 1 of 2024 for urgent hearing and early disposal of the essay, and the same is also pending. Mr. Niyamati is appearing for the opposite party number 2.
My lords, Bank of Baroda.
The Bank of Baroda.
My lord.
Opposite party number 2, Bank of Baroda. Let a status report be called for from opposite party number 1, and the file be placed before the land and register judicial results and so on. So he has to give it by 22nd for them. Matter be placed in the week commencing from 27th January 2020. Status of say essay number so on. Opposite party number 1 the register of the debt recovery. Say report there. Yeah.
Item 19.
2 weeks after. It is coming for the first time.
Yes.
All right. The Learning Council for the petitioner seeks for an adjournment for 2 weeks. Place this matter in the week commencing from 3rd February 2020.
Next, the
10th February 2025. No interim order is coming for the first time. Yes.
Single base matter, I think.
Single base. Adjournment matter time.
Matter settle.
Adjournment matter can settle.
Trying to settle it.
ଆପଣ ଯଦି ସିଓର ନୁହନ୍ତି ଆମେ କହିବୁ ରେଜିଷ୍ଟ୍ରି କୁ ଯେ ଏଟା whether it is a single bench matter or DB matter ଆପଣ adjournment ନେଇ ଯାଉଛନ୍ତି ନା ପୁଣି
10th February.
Yes, next.
Item 20.
Carried to annexure 3 at page 40. This is the possession notice under 8(1) of the security interest rules, which has been affixed on my property. The difficulty is that the property described here is not my property, and my property is something else. My lord, this opposite party number 2
The 13-4 notice you are challenging.
No, not 13(4). This possession notice, which has been pasted on my property, I have no difficulty in the bank recovering its loan. I am neither the loanee nor the guarantor, nor is my property mortgaged. The mortgage property is something else. They have come and affixed the possession notice on my property.
So you are out and out a stranger.
Absolutely. Opposite party number 3, before your lordship, he came and occupied my property, for which I filed a civil suit. The suit has been decreed in my favor, and he has been directed to be evicted therefrom. That property is something different. The property where the notice has been affixed. I am in no way connected with the property which is described in the possession notice. Unfortunately, it has been affixed on my property, thereby creating an attachment thereon.
What is the schedule of property in the civil suit?
Let us see that.
Yes. Civil suit, the judgment begins at page 14. The decree is at page 36. Page 37, your lordship sees schedule A.
कितने अनिश्चित कितने? Page number?
Page number 37.
37. Yes.
Page 37 is the decree, is a part of the decree where Schedule A is my property, on which I have obtained the decree.
Yes, this property was not kept on mortgage with the bank.
No,
Then which property was kept?
which has been described here in the possession notice, some other property. But it was by the opposite party number 3, the person against whom I have got this decree. Maybe he has shown my property, saying that this is the property which he has mortgaged.
No, directly is there or not?
Your Lordship kindly compares the plot number and the khata number in the possession notice. It doesn't match with the property on which I have my house. It has been purchased by me in 1986 and decreed by the civil court in my favor.
Right. Restitution of property. Page number annexure 4.
And I have brought this to the notice of the bank by annexure 5. They're sitting quietly over it.
69. What reply you have received from?
Nothing. Nothing. I followed up this letter with personal visits to the bank. Every time they say, we are looking into it. I say that if you look into it, kindly take off that notice for my property. They are doing nothing.
Suppose that particular property which has been on which this you say that this banner was placed. This
Notice has
possession
been
notice,
affixed. Yes, 8-1 notice has been affixed.
that is plot number 300 of so and so. That must have been given by this opposite party number 3, Siram Pandey.
Yes, he has taken the loan. He has taken the loan, but in respect of another property, that is plot number 300 by 3114. He has purchased this 3114, he has purchased that property. Having purchased that property, he has come and taken possession of my property, for which I filed the civil suit. The civil suit has been decreed in my favor, finding that he is in a wrong property. His sale deed is invalid. And I am to recover possession from him. Now I find that this is what has happened.
Who appears for Kotak Mahindra Bank?
Direct, I can take out notice. I am not aware as to who appears for this. I think notice on opposite party number 3 also is required. He is the most mischief monger.
These matters, so we should not entertain, because this, in view of the Supreme Court decision, since you are bringing something.
This is protection of my rights under 300A.
That's all right. That is the exactly thing we want to know. But they should have immediately replied to your notice dated so and so. This writ petition has been filed by the petitioner, Prasanna Kumar Rao. The prayer to pass the position notice dated 9/12/2024 issued by the opposite party number 1, Kotak Mahindra Bank, under annexure, which is stated to have been affixed on the gate of the land of the petitioner, releasing the charge created for the land in question, with a further direction to the opposite party number bank to unseal the land in question. The Land Council for the petitioner submits. Where is that statement that you have not availed any loan from that bank?
53 and 36. In my writ petition.
Yes.
Oh.
Para 7 is there as 4, line 4. The petitioner whose title has been declared by the competent civil court is not the borrower, nor it has mortgaged the land in question with the opposite party number. Para 7.
I'm obliged.
Submits that the petitioner instituted civil suit number 211 of 2016 before the Lenin Civil Judge First Court Cutter against one Mangal Prasad Gupta and opposite party number 3, Sriram Pandey, for declaration of right, title, interest and possession over the suit schedule A property along with consequential relief. By judgment and decree dated 23/2023, the London Senior Civil Judge Passport Cutter has been pleased to decree the suit against the defendants and the right, title, interest and possession of the plaintiff bracketed petitioner over the suit schedule A property was declared, and the defendant number 1, Mangal Prasad Gupta, was directed to give vacant possession of the suit premises to the petitioner within 3 months. And the defendants, including the opposite party number 3, were permanently restrained from entering upon the suit land and interfering in the peaceful possession of the petitioner in any manner after giving vacant possession of the suit premises to the petitioner. It is the contention of the London Council for the petitioner that the petitioner whose title has been declared by the competent civil court was neither the borrower nor he has mortgaged the land in question with the opposite party number 1 bank. And the opposite party number 3 and one Shubha Pandey are the borrowers. And since they defaulted to repay the amount borrowed, the bank proceeded to take action against them under the provisions of the Surface Act, but most peculiarly, the possession notice has been affixed on the gate of the land in question, which exclusively belong to the petitioner, and it nowhere relates to the opposite party number 3. And counsel submits that after such possession notice was affixed on his gate, the petitioner sought an application before the opposite party number 1 indicating therein that such notice on his gate has caused undue harassment and trauma to him, and it is required to be removed. However, the opposite party number 1 has paid deaf ear to the application made by the petitioner. Issue notice on the question of admission, indicating therein that the petitioner that the petition shall be disposed of at the stage of appeal. Mangal Prasad, opposite party number 2. Requisites for issuance of notice on the opposite parties be filed within a week. Matter be listed after 4 weeks, and counter affidavit, if any, be filed in the meantime. What further you want, Mr. Mukherjee?
Let them not proceed with the sale notice in respect of my property. Because 13.4 symbolic possession, they have on their record it has happened. Now, if they start,
we are mentioning that they should not proceed on your property. That's all we can say.
Yeah. In respect of Schedule A property in the suit as or Annexure 1 is my record of right.
Correct.
Annexure 1 is my record of right.
IN number so and so. This is an application for passing up to fate order. The opposite party bank is restrained until further orders to proceed on the property of the petitioner, which has been decreed in his favor by the Land and Senior Civil Judge Passport Cutter in so and so under Annexure 2 until further orders. Yes, I will. Like this. For yesterday, for
pardon mention, my lord. Appellant is languishing in jail custody more than 11 years. Is not, in jail, my lord.
Particularly of the hearing is appellant is for more than 11 years. Then he taken on orders.
Oh. Yeah.
Quickly list item number 1.
Item 1, there is power of my senior. As appointed by the court prisoner person. Thereafter, the accused in 2017 and this
Fine, let's ठीक है.
P5 2017 I have filed my vocal.
अच्छा. 2017.
My 5 2017.
Ascertain from the registry because the V-Nama has not been placed on record as yet. So, Mr. Mishra and
Another, my lord, pursuant to a prisoner petition in my name, I have filed this vocal. So another prisoner petition is also missing. Might be.
No, this prisoner's petition which we are having.
That is in the name of my learned senior one.
नहीं सेटा कहा ना नहीं.
He wanted a engagement of it.
That's all.
नहीं तापर आज्ञा आउ गोटे अछि जोथरे कि my learned senior को ना था.
That is not with us.
नहीं अच्छे record
अच्छी.
अछि I have verified.
अच्छी.
आगे I have verified it. That is, Lordship will get it at
Yes, it is there.
तापर आउ गोटे prisoner petition अछि सेटा missing.
That is dated 29/1/2016.
16.
Wrongly-
तापर आउ गोटे prisoner petition आसीगा सेटा missing. सेटा मो भोकला दिटा को missing.
You do one thing. Where is this man is now?
Now he is
Circle jail
my lord
Chodha.
circle jail 14.
14 जे superintendent को इसे लोग कोड़ा गाड़ी हो produce करें. What's your motive? है ना? What's your motive? Yes, please wait.
Item 2.
Take instruction. The run counsel for the appellant submits the real instruction whether the petitioner has surrendered after availing the interim bail period or not. But the report be called for from the London trial court, that is second additional session Judge Baripada Morgan in ST case number so and so. As to whether the petitioner availed the interim bail order as per the order dated so and so passed in IA number so on. And if so he has surrendered at right time or not, and if not, yes, my report to be received on such and such date and the file be placed on file be placed with the government registered with the sir, he will send intimation. Yeah.
Item 3.
Lordship on behalf of much taking action.
Mention is made on behalf of Mr. Chandra for argument.
Item 4.
15 years में लगा लो 15 years में can you see that's the order dated 7 years we had asked for the because
address verification ପାଇଁ address ଠିକ ଅଛି
Only PS name.
Take the moment. This is Jayaprakash Verma alias Sikandar Verma, Mehta, son of Amarjit Tigachi, village Shiva, Shivapur. It out of the Kai. Shiv, they are in the Kai. PSOC,
Yes, PS1.
it out in Sulakai. PS Society, Jambar, Mane, Jambar, you here, Amoro, judgment to the Kai or Galakai. English and now Galakai. How PS done
people present with the happy.
So you are in custody for 15 years.
15 years, 9 months, 6 days in this. I think 16/11/2023. Bharat Bharat are you forgiven? At present, sir.
At present.
At present.
Originally, it was
PS Jammu ଅଛି it PS
ସେ PS ଟା କାଟି ଗୋଟେ ଏରିଆ
delimitation
delimitation village ଟା change ହବା କଥା ନାହିଁ
village ଟା କୋଉଟା
So you please give that local sureties who are interested to take one. The as per order dated 19/12/2020, the Land and Council for the state has produced the address verification report of the appellant the Superintendent of Police Jharsuguda, which is taken on record. Let the Land Council for the appellant produce the name, address, and documents of the local sureties who are interested to take the appellant on. Time limit instruction matters. You supply this information within a week.
Can you give me 10 days time?
2 weeks, all right. 2 weeks, within 2 weeks to the State Council, whereafter he will obtain instruction regarding the willingness of the local sureties to take so and so, and the authenticity of the document. All right. So it appears whether
Item 5.
Item 5, my lord, has not served a copy of the judgment, my lord. खाली अपील मेमो अछि मिस्टेक गुडा कर
6.2 copy.
ना कॉपी दिया है पण ता भीतर
judgment copy दियंतु The Land Council for the state submits that though he has received the copy of the appeal memo from the Land Council for the appellant, but the impugned judgment copy has not been sought. Land Council for the appellant submits that he will supply the judgment copy to the Land Council for the state by 15th January 2025. 15 तारीख भीतर जजमेंट दियंतु ताला आसंदा सप्ताह आसीबो. List this list this matter on 20th of January 2025. अच्छा ये आपनकर जो लिखि दंता ऊपर लिख दूं prisoners petition has been received for engagement of so and so. Wakalatnama has been filed, accepted. Bina Pani Tripathi and Nandini Tripathi accepted. The name of other councils are not the
Item 15 January.
20th. By 15th you have to.
हाँ 20 तारीख रे मैटर आसीओ लिस्ट रे आपण एई सप्ताह भितरे जजमेंट रो कॉपी टी सरकारी उपलब्ध दे दो. यस
Item 6.
सरेंडर सर्टिफिकेट प्रोड्यूस कर चला रोला गया लेकिन नॉन ऑब्वियस सेम ऑर्डर कर दे है the directed to be released on bail. No surrender certificate has been produced. Let instruction be obtained from the land trial. Whether he was apprehended or not, bail order as per order. And if so, whether he has surrendered or night time or not, if not, what steps have been taken. Time jim ticket arata thila se type of. Yeah.
Item 7.
Item 7 over the term next. And we are on the
Mention is made on behalf of Mr. Amul Pratanda for adjournment. Is this matter? Again, next.
Item 8.
Business petition count as. Now, I would read that, but it's like that test. Doctor opinion, or a meter for opinion. This could there's a mobile
Because S fund appears. Because S fund has been.
S fund I'm going to speak privately and
Private.
so say Gramjit Panda for बोले अच्छा फिर नॉन ऑब्वियस कर दिया अर्जुन को नेक्स्ट.
Item 9.
A type product. Surrender certificate not produced from appears, instruction me about surrender for China as per order dated, whether he has been released from them.
Item 10.
Yes, option.
Yes, Mr. Nayak.
Option.
How many years?
The Kumbamunda,
How many appellants are there?
2 appellants are there. In the Appeal 14, no, ମୁଁ ଗୋଟେ କରି ଯାଉଛି. Criminal Appeal 14, Kumbamunda and Ratnamunda are there. Kumbamunda in custody, 3,447 days.
ସେମିତି କୁହନ୍ତୁ ଆପଣ years କୁହନ୍ତୁ.
9 years, 4 months.
More than 9 years. Okay. ତାପରେ appellant number 2.
Ratnamunda, same, 3,004.
ଆଚ୍ଛା
9 years.
ଇଏ ଗଲା ଯୋଉ ପ୍ରଥମଟା ଯୋଉଟା 14
ନାଇଁ
2020 ନେକ୍ସଟ ଆସିଲା 13 2020
13/20.
ତାହେଲେ କିଏ କେତେ ଜଣ ଜଣେ ନା
3 accused person are there.
3
Manual.
ଅପିଲ ମେମୋ
All are 9 years sum order.
ଆଚ୍ଛା
Here, in all the cases, 9 years sum order.
1 8 2 8 3 9 years more than 9 years.
More than 9
Okay. ତାପରେ ନେକ୍ସଟ ଆସିଲା
Ishwar Munda.
550
Manual.
2020 ସେ କେତେ
3,400. Same data. All the accused. 6% killed. From one family, 6 person killed, 2 survive. Both the injured eyewitness to the occurrence.
Yes.
How many persons died?
6%.
6%.
ଗୋଟେ ପରିବାରର 6 ଜଣ ବାପା ମା, 2ଟା ଭଉଣୀ, 2ଟା ଭାଇ କି କଲେ, 2ଟା ଭାଇ କେବଳ ସେଭ୍ ହେଇଯାଇଛି. And
So
they are
4
also
persons
injured.
died.
6% died.
6%.
Yes.
Yeah, what is your submission?
Suspecting to practicing witchcraft, they have committed murder of minor. So far as the this is concerned, basing upon the PW 13 and 14, the trial court relied upon the basing of the statement of 13 and 14 Lordship. Lordship kindly gone to 13 and 14.
They are the injured witnesses.
Yes.
So when you have killed 6 persons, why bail will be granted to you? When the matter will be taken up for
Paperbook already ready.
paperbook is also ready.
Only my lord, basing upon the leading to discovery and
Eyewitness statement ଅଛି ପରା.
Eyewitness
none
statement,
of the
leading to discovery also is there.
so far as the present petition is concerned, none of this statement against me, my lord.
No, eyewitness ही କହୁଛନ୍ତି eyewitness ଅଛନ୍ତି ଦିଟା case PW 13 and 14.
Yes.
13, 14 and PW 15. The person who rescued the PW 14 and taken to the to police station, he also stated.
13,
Because
14,
first PW 14 disclosed the fact before PW 15 near a railway track in the early morning. The PW 15 lifted the
ତେରଟାକୁ ଆସିଲେ ଆପଣ the accused persons please come to PW 13. You have received the paper.
Yes.
278 man.
PW 13 ବି ଛୋଟ ପିଲାଟା, ସେ 9 ବର୍ଷ ଯେତେବେଳେ ହେଇଥିଲା ତାକୁ
ये ଦି ଜଣ ନାଁ କହୁଛି accused ଈଶ୍ୱର ଆଉ ସୁନିଆ. Accused Ishwar stabbed by means of trisur onto my belly, causing injury, and intestine came out. After such assault, I lie on the ground. The witness identified Deepak Munda as Ishwar. ଗୋଟେ wrong identification ଅଛି, ବାକି ଗୋଟେ କହୁଛି ନାଇଁ ସେଇ ଈଶ୍ୱରଟାକୁ wrong identify କରୁ. I could not identify the assailants one, so अच्छा. ବାକି ରହିଲା 14. 14 କଣ କହୁଛି?
We are 4 brothers and 2 sisters residing at Lahanda with our parents, 11 person, para 3. On the incident night at 11 to 12 p.m., Accused Mansingh Munda came and asked Hoini Bhutuka to me. At that time, I, along with my brother Shambhu and Sunil, slept inside the house, and my parents, with other children, slept outside the house. Accused Mansingh called me Chanda Chanda Hoini Tikete, and I got up, gave him Khoini. I could identify him due to electric current. The accused Mansingh left my house, and again I slept. After 2 to 3 minutes, I heard the noise of my mother, and immediately I woke up, came outside the house, and noticed the dead bodies of my father, Guromunda, mother, and a brother, and two sisters with full of blood. Out of fear, I came inside the house and closed the door. Then accused person Ishwar and Sunya forcibly entered inside the house by opening the door and stabbed my brother Sunil by means of Gupti MO3. He instantly died. The accused Ishwara stabbed my brother Shambhu by means of 3-point edge weapon Trishul to his belly, as a result of which his intestine came out. Out of fear, I concealed myself under a cot and witnessed the occurrence. Then the accused Ishwara raised a noise by saying, "Tara bada puo kuade gala." The accused Sunya then removed me from the place of concealment and brought me out and dealt a Gupti MO3 blow on my belly, causing bleeding injury. The accused Tumba dealt iron blow to my backside. Then I ran away from the spot towards the jungle. I remained inside the jungle whole night. In the early morning, while proceeding to Vilaipada outpost through railway track, meet a person who gave me water. Disclosed the fact to him. He brought me to Vilaipada outpost. Orally, I reported the matter to
ତାହେଲେ
police.
ଏ ଲୋକଟା ମାନସିଂ ନା କହୁଛି ଈଶ୍ୱର
Mansingh is not an assailant. He is a juvenile.
ଆଚ୍ଛା
His trial was conducted.
ମାନସିଂ ଛାଡି ଦିଅ ଈଶ୍ୱର ଅଛି
ଈଶ୍ୱର ଅଛି,
ସୁଇନ
ଶୂନ୍ୟ,
ସୁନିଆ ସୁନିଆ ତାପରେ କଣ ତୁମ୍ବା ଗୋଟେ କହୁଛି
ତୁମ୍ବା।
ଏ ତିନି ଜଣ ନା ଆଟଲିଷ୍ଟ ଅଛି ୟା ଷ୍ଟେଟମେଣ୍ଟରେ କାହା ନା ନାହିଁ କହୁଛନ୍ତି
ବାଗିନା ମୁଟା ମ୍ୟାଡାମ
ଆଁ?
ବାଗିନା ମୁଟା
The occurrence took place in the dead hour of the night. All have first killed the
midnight.
parents and four sisters, two sisters and one brother of the petitioner. That is outside they are sleeping in the veranda. On hearing the
No, what he says that this particular accused has not been named, identified by anyone. ये जो कौन गोटे ना कहउचंती सेतपे आपण देखुनांती से जो पर्टिकुलर accused विषय से कहउचंती ठीक
ଆଉ
कोन
ସେଟା
ता
ବୀରେନ୍ଦ୍ର
ବାଗନ ମୁଟା
ହଁ
ବାଗନ ମୁଟା
ବାଗୁନ ମୁଣ୍ଡା ବାଗୁନ ମୁଣ୍ଡା ନା କେହି କହିଛନ୍ତି କି ତାର ପ୍ରେଜେନ୍ସ ଇଏ ଥିଲା ଘଟଣା ଜାଗାରେ କି ତାର ଓଭରଟାକ୍ଟ ଏଇଆ କାରଣ ଆପଣ ଯୋଉ ତିନି ଜଣକୁ କହିଲେ 13, 14, 15 ଏ ବାଗୁନ ମୁଣ୍ଡା ନା ତାଙ୍କ ଇଏରେ ନାହିଁ ଏବଂ କି ବାଗୁନ ମୁଣ୍ଡାକୁ ସେମାନେ ଦେଖିଥିଲେ ବୋଲି ଘଟଣା ଜାଗାରେ ଉପସ୍ଥିତ ଥିଲା ଅନ୍ୟ ମୁଦାଲାଙ୍କ ସହିତ ବିଷୟରେ ମଧ୍ୟ ନାହିଁ ସେ ଯାହା କହିବା କଥା
ମୁଁ ଟିକେ ତାକୁ ଆଉ
ହଁ ଦେଖିଦିଅନ୍ତୁ କିଛି ଅସୁବିଧା ନାହିଁ ବଟ୍ କୋଆକ୍ୟୁ ଷ୍ଟେଟମେଣ୍ଟରେ ଅଛି ଯୋଉ 15 ନମ୍ବରରେ ନାଇଁ ଆଚ୍ଛା 15 ନମ୍ବରକୁ ଆସିଲେ ବାଗୁନ ମୁଣ୍ଡା ନା ସେଥିରେ about 2 years in the early morning, I had been to this one. I heard a noise from a boil. Then I put my torch and saw the informant imbue having bleeding injury on the belly, where he himself put his hand. When I asked, he disclosed that accused persons, so and so, others killed his parent. So he has stated about your statement. Informant ki?
PW14 ମ୍ୟାଡାମ
PW14. ଦେଖିବା ଅଛି paragraph 2 ରେ paragraph 2 ରେ they are the accused Bagun asked my parents to leave the village or else to kill me. to hang suspecting my parents so and so. My parents then told to bring Handi and the so and so to take oath that they are not practicing so and so, but the villagers did not agree to lie. After on the date of our occurrence, Mansingh so and so came.
Prior to the occurrence, my lord.
There was a village meeting.
Yes.
And all the accused persons were present, and they alleged that the mother of the petitioner is practicing witchcraft.
ନା ନା ଏ କେସ୍ ଆପଣ 6ଟା ମର୍ଡର ହେଲାଣି ଆପଣ ଆର୍ଗୁ କରନ୍ତୁ. Had the land and council for the petitioner, land and council for the state. It's a case where the 6 murders have been committed. In view of the eyewitnesses account and available material on them, we are not inclined to release the petitioner on bail. सब गुड़ा का bail release करते हैं, है ना? और जो stay relation of fine अच्छी तरह अलग है. Since paperwork has been prepared, matter we added to the hearing list in regular course. Next.
Item 11.
May I please do it? Application for the interim bail, my lord. One of the appellants, my lord. But for one of the appellants, my lord, I have prayed for the interim bail, my lord, for 3 months. Mother is my lord.
Debo Maji.
My lord, Debo Maji.
On what ground?
My lord, my mother is suffering from, my lord, hemiplegia, my lord.
No, whether the instruction has been sought for?
No, my
No,
lord.
the first time actually.
First time.
So have you received the copy of the interim application?
Yes.
And with the medical document also?
Yes, sir.
All right, take instruction. IA number 3012 of 2024. This is an application for interim bail for
appellant number 1.
Appellant number 1, Debo Machi. Land counsel for the petitioner submits that the mother of the petitioner is suffering from so and so, and she was admitted in so paragraph 4 replies. Medical document in respect of the government's taken in the interim application has been filed. Copy of the same has been served on the land council for the state to seek some time to obtain instruction on the same. Out of this matter, and for chances that give it 8 years.
Lordship, I'm appearing on behalf of appellant number 8, Your Lordship. I'm appearing on behalf of appellant number 8, Your Lordship.
Yes.
And on the bail application, interim application for bail, Your Lordship.
Which is your bail application?
The common bail application, Lordship, IA number 83 of 2026.
Nori Maji.
Yes, Your Lordship.
Common and Asura. One of the separate here and the appear question the appellant number 1 fine. So if you want, you are only engaged for this appellant number 8. You file a separate application. Alright. That would be yes. Next.
Lordship, fix up the date.
We are fixing it only for this IN number 3012 of 24 that has been filed for interim bail of appellant number 1 on the ground of his mother's ailments. So if you want, your bail application should also be considered, file an interim application, file the memo so that it will be get listed, then we will see. Yes.
Okay, sir. Item 12.
Pursuant to the order of 2511, the instruction was sought for. I pray for next week.
What instruction we sought for?
The criminal antecedent and the status of 2 children of the deceased. I pray for 1 week.
Land counsel for the petitioner submits, that is IN number 003 of 2022. That as per the order dated so and so, instruction has already been sought.
I am for the fixing.
Government can land counsel for the state submit that instruction has already been sought for terms of the order dated 25/11/24, and the matter may be taken up the week after this matter will be commencing from Satish 27/1/2025. Yes. here. Admission and to the chairman. Sanjay Das. Hey, what happened to that? Did you join that? मैं ऐसे नहीं था कौन तो ज्वाइन करे वो कौन Mr. Das, this matter you are to argue or Mr. Sanjay Das? Maharana. And he's ill today. He has not come. And another thing, in the last order, you were referring the order that copy has been served to me and it has to vigilance. It has not been served by the government. So far as that. Just a minute. It has not been served. Which copy? The counter filed by the government, your lordship rejected and passed a fresh order. It's a very different order. Yes. To the secretary, but the joint secretary again filed the same thing, copying the vigilance affidavit. Same thing. It has been copied and filed again. Filed a fresh affidavit, so also. There is no difference. That's also. You have got that copy with you. So solve it. And anything further you want. So who is to argue the matter? We'll record it today so that we are adjourning. If you want, we can adjourn the matter, but it should be finished. You will argue the matter. Mr. Shiman Das and we'll mention that senior counsel for the vigilance department or senior counsel for the vigilance department submits that he is yet to receive the phrase affidavit filed by the secretary, Home Department, Government of Orissa, as per the order dated Joint Secretary. Joint Secretary. Order was to the secretary, but Joint Secretary, as per the order dated 13/11/2024. Learned Council for the state handed over
Yes,
handed over the affidavit copy to the Land Council, Mr. Simon Das, in court. Took some time to go through this and put up this matter on 20th of January 2025. There was a suddenly Land Council for the appellant is present. The petitioner is present. And this is to come with CRL number 84 of 2017. Here. It's a copy of their counter only, vigilance counter. It's a copy of the vigilance counter. We see the next. The order টা দেখছেনতি যেটা লিখিছিল আমি ডিটেইলস এই অর্ডারটা হ্যাঁ সেটা yes
Item 21.
Have you filed any?
I 6 of 25.
6 of. What is the delay shown by the stamp reporter?
41 days.
Fine. Stamp reporting টা jail criminal appeal. IN number 6 of 2025 is an application for condonation of delay. The stamp reporter has shown 341 days delay since the appellant has been sentenced to life imprisonment. It's a jail criminal appeal. After hearing the land council, the party, they are inclined to condone the delay. Accordingly, delay is condoned. IA is disposed of. Hard admit call for the trial stop. Trial court record is already there. So you have got the deposition copies with you.
I have everything, and tomorrow, day after tomorrow, I will file bail application for the appellant. So
Just a minute, Mr. Counsel, there are two other applications, one for stay realization of fine, another for bail.
sterilization fine is 7 of 25 that I filed, and another bail application of previously counsel filed. That I
You don't want to press that.
I don't want to press. I will file press bail.
So what about stay realization of fine?
File 7 of 25.
7 में लिस्टটা দেখুন না দেখি
সেটা 4 ଅଛି
ଗୋଟେ ହଉଛି 3 of 2024 stay realization of fine ଆଉ ଗୋଟେ 4 of 2024 bail application
ଚାରିଟା not pressed.
अच्छा IN number 4 of 2024 the Land Council for the petitioner does not want to press this application. Accordingly, IA is disposed of. बाकी
7 is also stay realization.
7 है
IA 7.
ठीक लिस्ट है जो 3 of 2024 तीनটা আগুর ফাইল করছেন সেটা বি স্টে রিলেশন
হ্যাঁ স্টে রিলেশন
তাহলে সেটাও নট প্রেস করে দিবেন
এটা not press করি মোর
আচ্ছা এইটা এই যে IA 3 of 2024 টাকে নট প্রেস করে দিবেন তো है ना since he has already filed another application for stay of realization of fine, that is IA number 7 of 2025 है ना और IA number 7 2025 টারে stay realization of fine allow করে দেন ହେଲା ବାକି ସେ ବେଲ୍ ଯେତେବେଳେ ଫାଇଲ୍ କରିବେ ଲିଷ୍ଟ ହବ
problem.
Number 1, item number 47.
କଣ ହେଲା ସେ ଆସିଲେ
Dockegency assembly ଗଣେଶ
ଡକେଇଛନ୍ତି ମାନେ କୋଉଠୁ
ଜେଲ ଭିତରେ ରହୁଛନ୍ତି
just to be ascertained because two counsel name he has given, one is Ramanikant Patnaik, the other is Mr. Mishra. So Ramanikant Patnaik's wakalatnama is there, but Mr. Mishra's wakalatnama is not there, but he has stated that he has already filed. So once it is ascertained that he wants to engage with counsel, the necessary order can be passed. That is the reason why we are calling for.
Ready for hearing.
7.
47 you are ready.
I'm ready. Last opinion I will mention that appellant is in custody for about 18 years. 18 ବର୍ଷ ରହିଲାଣି hearingଟା କରିବେ ଫର୍ମାଲିଟି ନାହିଁ
ନାଇଁ ନାଇଁ ଆପଣ ସିଏ ଏଇଗୁଡା କୁଆଡେ ଗଲା ଏଇ ଯୋଉ 23-24 ର ଜେଲ କ୍ରିମିନାଲ ଅପିଲ ଅଛି ସିଏ କେହି ନାହାନ୍ତି
2008
I am 29, my lord. 26.
Pasmita number 26
I am 29. 29 I will conduct, my lord. ছোটটা যেটা আছে সেটা করতে হবে
26 टा आपनकर ना नहीं
ମୋର
29 टे भी आपन
हाँ
जो व्हाट अबाउट 23 मीना कुमारी दास
সেটা লাস্ট টাইম লর্ডশিপ ডাইরেক্টেড টু অশোক সাহু অশোক
We have changed it.
অক্ষয় সাহু
23. S.K.Sahoo, yes. He was there that day.
ଏଟା 2007 ମସିହାର
Mr. S.K.Sahoo and counsel for the appellant
taking
submitted
into
the
account
certificate.
there is a jail criminal appeal of the year 2007 we engaged him now he is not there that this man is still in custody or might have been released prematurely who knows that about because this is the case of the year 2001 ST case 2001 माने ते ये का केस के बेकरा पेपर बुक भर के otherwise unnecessarily it would be it's a 2001 is big FIR you obtain about the status of this because sometimes they have been released also prematurely and intimation is not given to the court and they obviously they are not interested after being released prematurely he was the it indicates that maybe in Kalahandi jail and that Bhavani Patna
Verification Kalahandi that can be ascertained that
लिखी दियो
It was not in different type. The second case was disposed
हाँ
in type. Must have been
2007 जो appeal file is jail criminal appeal there is a non appeals for the appellant the case out of which this jail criminal appeal arises is of the year 2001 final form টা করো
taken to custody on 22/2008.
and the petitioner was the appellant was taken into judicial custody on 23/2/2001 let the learned counsel for the state obtain instruction about the status of the appellant and this period of detention of put of this matter out of date of change. Free copy of the order will be handed over to. What about the next one? Jail Criminal Appeal 21 of 2010. Secretary Council assign a lawyer.
Anjan Kumar Rana and Mr. Radharaman Das Naik. Yes, by OHCL.
But I will be able.
And received from the district Polangi regarding the Inspector Anjan Kumar Rana at flats of the and at a subsequent 12 ठीक है तो 24 में जो ये ऑफिस में 12 बजे फीस डे order sheet. तापरे was engagement. Even Dinesh Kumar Sahu to receive to Bharat to second officer. तापरे product policy engagement. Ranjan Rana agent after ଗୋଟେ order ଆସିଛି Ranjan Rana and Radharaman Das Patnaik engaged ଦି ଜଣ ଯାଉଛନ୍ତି 24/22 ର order ଲେଖା ହେଇଛି the order sheet ଟା ଯୋଉ ଏଇଟା ଦି ଜଣ ଯାକ କେହି ନାହାନ୍ତି ଏଟାର ବି status ଆଣନ୍ତୁ ହେଲା ଲେଖନ୍ତୁ even though Orissa High Court Legal Services Authority Committee has engaged Mr. Ranjan Kumar Rana and Mr. Radharaman Das Naik to conduct the appeal on behalf of the non-appears. Since it's a trial court deputative happening, since the case is of the year 2009 and the appellant in judicial custody since 17/2000 appellant the petition prisoner judgment श्रीमती विनोदिनी हुई और डॉक्टर हुई अच्छा मैं स्वामी श्री ट्रायल पेश कर लें inclined to imposition accordingly on his conviction. Not guilty to page number 31. Or not guilty is you let it have been no dini koi single accused page number 31. Second accused doctor conviction gote appellant hala date ta lekhi kebut custody appellant in judicial custody since 1/7/2009 and counsel for the state shall obtain about the status of the appellant hala and also
if he wants to engage in counsel on his own or a counsel from the appellate services engaged by this court, so also the period of detention for the custody certificate to be obtained. Yes, next. What is Mr. Rajesh Tripathi?
I said Thursday kindly be taken up.
Who da?
See Rajesh.
Asha. And you are not ready in item number 26.
Again.
Okay, we'll go serially. What about 27, Mr. Niranjan Panda? He's not there. Asile ki see you. Virtually it alaga. Tera किस number item?
Item 1.
Item 1 talo.
Item 1.
No, Chaudhar ji alaga.
Kindly unmute Chaudhar ji.
Unmute करंतु.
Sir, kindly unmute.
चौधरी जेल सुपरिटेंडेंट unmute करंतु. Unmute करंतु.
ଗଣେଶ୍ୱର ଏଲିଆସ୍ ରାଜା ମହନ୍ତ କାହାକୁ ଓକିଲ ଭାବରେ ଆପଣ ଦେଇଛନ୍ତି?
ଆଜ୍ଞା
ଓକିଲ ଭାବରେ ଆପଣ କାହାକୁ ରଖିବା ଲାଗି ଦେଇଥିଲେ ପତ୍ର?
ସାର୍ ଘର ଲୋକ ଦେଇଥିଲେ, କାହାକୁ ଦେଇଛନ୍ତି ତାଙ୍କ ନାଁ ଦେଇନାହାନ୍ତି।
ନାଇଁ ରମଣୀକାନ୍ତ ପଟ୍ଟନାୟକକୁ ଦେଇଥିଲେ?
ମୁଁ ସାର୍ ଫାଷ୍ଟ ଦେଇଥିଲି ରମଣୀକାନ୍ତ ପଟ୍ଟନାୟକ, ତାପରେ ଘର ଲୋକ କହୁଛନ୍ତି ଆମେ ଦେଇଛୁ ବୋଲି ଓକିଲ।
ନା ଏଇଠି ଆଡଭୋକେଟ ଅରିଜିତ ମିଶ୍ର ଅଛନ୍ତି, ସେ କହୁଥିଲେ ତାଙ୍କୁ ମଧ୍ୟ ଦିଆ ହେଇଥିଲା ବୋଲିକି।
ଆଜ୍ଞା
କଣ କହୁଛନ୍ତି? ଅରିଜିତ ମିଶ୍ରଙ୍କୁ ରଖିଛନ୍ତି ନା ବର୍ତ୍ତମାନ ରମଣୀକାନ୍ତ ପଟ୍ଟନାୟକକୁ ରଖିଛନ୍ତି?
ଘର ଲୋକ ଦେଇଛନ୍ତି, ତାପରେ
ତାଙ୍କୁ ପଚାରିକି କହିବେ, ଘର ଲୋକଙ୍କୁ ପଚାରିକିରି କହିବେ କି? ସମୟ ଦରକାର,
ଆଜ୍ଞା
ସମୟ ଦେଲେ ଘର ଲୋକଙ୍କୁ ପଚାରିକିରି କହିବେ।
ଆଜ୍ଞା
ଆଚ୍ଛା
ଆସନ୍ତା ସପ୍ତାହରେ ରଖୁଛୁ, ଆପଣ ପଚାରିକିନି କହିବେ କାହାକୁ ଆପଣ ଓକିଲ ଭାବରେ ଆପଣ କେସ୍ ପରିଚାଳନା କରିବାକୁ ଦେବାକୁ ଚାହୁଁଛନ୍ତି। ଲେଖି ଦିଅନ୍ତୁ ଗଣେଶ୍ୱର ଆଲିଆସ୍ ରାଜା ମହନ୍ତ
ନମ୍ବର ଦେଇଛୁ କିନ୍ତୁ
time may be granted till next week to ascertain the to tell the name of the land and council whom he wants to engage to conduct the appeal. So, of this matter on 27th of January 2025, the jail superintendent Swanshu shall ensure the attendance of the appellant through virtual mode on that day.
27 ତାରିଖକୁ ଧାର୍ଯ୍ୟ କରାଗଲା। 27 ତାରିଖ ପୂର୍ବରୁ ଘର ଲୋକଙ୍କ ସହିତ କଥାବାର୍ତ୍ତା କରି ଓକିଲ ବାବୁ କାହାକୁ ଦେଇଛନ୍ତି ସେଟା 27 ତାରିଖ ଦିନ କହିବେ।
ऑनलाइन भी रहिबो
ऑनलाइन रहिकरी कहबे
कौन सी कहउछन सेटा कोन अनम्यूट हे जाई अनम्यूट हे
अनम्यूट नहीं म्यूट हे अनम्यूट करंतु
म्यूट हे अनम्यूट करन
गोटे सेकंड कोन कहले चाहते सेपटरू आपण म्यूट करछन ताके अनम्यूट करंतु
सेपटरू कथा शुभुनी
हां कहंतु
पचारि बुझी कहू
सर पचारि बुझियो
आमे 27 तारिख दिन दिन धार्य करिचु केस टाकू रखा होची 27 तारिख दिन ता पूर्वरु घर लोकंक सहित कथावार्ता करी काहाकू वकील भाव रे दबाकू चाहुचंती 27 तारिख दिन कहिबे
ठीक अछि हां
दुईटा बेला कहिबे
ठीक है
नमस्कार बंद 27 तारीख
Kindly pass another order with regard to my wakalat number. It is not in the record.
as Mr. Arijit Mr. submit that he has filed wakalat nama
On 3/5/2017.
on 3/5/2017
17
the registry may place the same on record बाकी item number 27 Niranjan Panda okay. Item number 28 Sahu काजी कोन भलो दिन न you are having that paper
Yes,
book
ma'am.
with
Yes,
you.
ma'am. I have also prepared. I have also prepared the.
No, it's all right. So, ଆପଣ ଭିତରେ distribute କରିଦିଅନ୍ତୁ କାରଣ day after tomorrow ହଉଛି ଆଙ୍କ matter ଟା ନିଆହବ Mr. ସାହୁଙ୍କ matter ଟା କାରଣ ଇଏ ରହିଛି ରାଜେଶ ତ୍ରିପାଠୀଙ୍କ matter ଟା ରହିଲା 25 ତାରିଖ ଦିନ item number 25 ଟା ରହିଲା Thursday ଦିନ ତେଣୁ you get ready someone of you item number 28 ଆଉ ବାକି ମିସ୍ ନନ୍ଦଙ୍କର matter ଟା ଯୋଉଟା ରହିଛି item number 29 ମଧ୍ୟ ଗୋଟେ ready ହେଇଯାଆନ୍ତୁ ହେଲା
May I please item 30 also I'm ready so the first day I
okay 30 you have received the paper book
ମାନେ
এই তিনটা matter ଆପଣ ready ହେଇଯାଆନ୍ତୁ
item 47 ଟା 18 ବର୍ଷ ରହିବ item
47 ଟା ମଧ୍ୟ ଇଏ କରନ୍ତୁ ହେଲା
47 last of week ରେ କହିଥିଲି ତାଙ୍କ ପାଖରେ ଅଛି
get ready will take up this
ସେ 2008 2008 appeal complete ମାନେ 18 ବର୍ଷ ରହିବ